Good evening. Welcome to the February 21st, 2024 Board of Adjustment meeting. The first order of business will be the approval of minutes. Approval of the January 23rd, 2024 minutes. I'll ask for a motion to approve them.
Madam Chair, I have comments. Are those allowed?
You mean to modify them?
The minutes, correct.
Oh, sure, just move to approve with modifications or something.
Yeah, I don't know if anyone else has changes that they have to the minutes. I do. Yeah, I believe,
Should we make a
Member Rossi.
motion to approve and then add our changes, or make the changes now? I think,
I would await a motion to approve, make any changes, and then we'll vote on the change, the minutes as changed.
bingo. I move to approve the minutes submitted, subject to changes that we discussed.
Second.
Okay, and Mr. Aum, your changes?
yes, thank you, Madam Chair. On page 9 of the minutes, page 12 of our packet, in the discussion in the first paragraph that starts with Mr. Rayom, it never really captures the second criteria that I said that the item failed on, which was the hardship criteria. So it needs a sentence added in there that makes that clear, that the hardship was the second criteria that was identified as the reason why the petition failed. Further down on page 11 of the minutes, page 14 of our packet, the decision of the board starts off as Mr. Rossi said granting the variances. I believe that was myself that said that, and then Mr. Rossi was the second. So Mr. Rossi in the beginning of that sentence needs to change to my name. And that is all I have. Thank you.
Any other changes? Mr. Rossi?
On page 5, the penultimate paragraph begins, Mr. Rossi said, criterion number 5, et cetera, et cetera. There is a sentence about halfway down the paragraph that says, Mr. Rossi surmised that there was no quantitative analysis. It should be Mr. Rossi observed. It's really not it's really not surmising. It's an observation. And a couple of other ones. There is, on page 7, the last paragraph, there's the second sentence begins, he said one was criterion, so on and so forth. No creation of traffic hazard, or it should be or, and not of substantial increase. And yeah, the other one I had was the one that Mr. Rayum already pointed out, so I'm good.
Are there any other changes?
My doppelganger.
Yeah.
None other? So I will just make one myself. Thank you, Ms. Gefford, for noticing it. On the top of page 4, it says Vice Chair Marge. I'm actually Vice Chair Margeson. So if I could have that change. And so a roll, just so to approve the meeting minutes was the changes as noted. All in favor?
Aye.
Aye. And chair votes aye. Any opposed? Okay, the minutes are approved. Next, we'll move on to old business. We have a request to withdraw. The request of Geary Portsmouth 505 Incorporated owner. And in order for this to be withdrawn, I will need 2 votes. I'll need a vote to suspend the rules. So if I could,
Motion to suspend the rules?
Second.
all in favor?
Aye.
Chair votes aye. And then I'll need another vote to accept the withdrawal request. Mr.
Make a
Mennel?
Motion to accept the withdrawal request?
Second.
And all in favor?
Aye.
Aye.
And then the next one is request to postpone. This is for Friends of Lafayette House in care of Melanie Mertz. We had 413 Lafayette Road. We had this last month as another postponement. I've talked with Steph, and she has agreed that any postponement will have to be renoticed. So we just asked for us to vote to postpone this.
Motion postpone?
Second. All in favor?
Aye.
Aye.
Any opposed? And the chair votes aye.
I'm sorry, who was the second on that?
Jody.
Okay, thank you.
And before we proceed to tonight's applications, I would like a motion to take item C under new business out of order, and we'll need a second. And if I get those motions, I'll explain why.
So moved.
Second.
Okay, so I had, before I knew I was going to be the chair of tonight's meeting, I had a conversation with the chair, Phyllis Edridge, who is ill tonight. She's not able to make it, and Steph, and they consulted with the city attorney on this. This is an application that was before us, I think, in October. It was denied, and that appeal is now pending before the Housing Appeal Board. I raised concerns about the fact that we kind of technically have two applications before the board at the same time. And so Attorney McCourt gave us three options for how we could deal with this. And the first option is that we determine that the BOA rules preclude the submission of a second application until the first application is completely final. And you'll note in our rules, it's Rule 7, miscellaneous number 4, the applicant shall be allowed to have only one active application before the board at any time. Additional applications will be rejected by the staff at the time it is submitted for proceeding. Apparently, Mr. Trevor McCourt agreed to stay the proceeding pending this application. The second possibility for us is to determine that the second application fails the so-called Fisher v. Dover test. And the third is to hear the application on its merits and treat it like a new application. I have my own ideas on how I think that this should be handled, so I would see what the other members of the board think. Mr. Rossi?
I'll be recusing myself from any
Oh, that's right,
discussion.
that's right. Ms. Geffert?
May I ask a question?
Sure.
So the appeal before the Housing Appeals Board is stayed presently?
Yes, so that by agreement, I guess, between the city and the applicant. So, the concern is that it stayed, and then we have another application coming forward.
Because stayed doesn't mean dismissed. It means if I'm understanding it, that would go forward if we denied tonight for whatever reason. Is that correct? Or what's the basis for the stay? That's, I guess, what I'm trying to understand.
I don't know, I would ask Stephanie, because I didn't have the conversations with Attorney McCourt.
The only conversation I had with Attorney McCourt was the email that you have in front of you.
Okay.
Madam Chair, may I be heard on this?
No, I'm sorry, it's not a public hearing. We're just taking out of order to discuss it amongst ourselves and the
Well,
board.
there's background on this.
I know, but this is not a public hearing yet. We haven't called it for a hearing. We're discussing about how to proceed.
With all due respect, I understand, but it seems to me that the affected party should be heard before there's a decision made. Thank you.
Okay, thank you.
Do you want me to read the email?
Sure.
Okay. So the context is Vice Chair brought up her concern. I directed it towards Attorney McCourt, and this is what I got in response. Steph, I agreed to stay the appeal, which is pending before the Housing Appeals Board. I did so with the agreement from Attorney Phoenix and Kaiser that they would only pursue one variance application to final approval. My reading of the Board of Adjustment rules indicate that the appeal currently pending before the Housing Appeals Board is no longer pending before the BOA, and therefore staff could accept the second application. This is, of course, the BOA's final decision. It is the law of the land that courts will defer to administrative bodies' interpretation of their own rules if at all possible. That said, as I see it, tonight, the BOA could do one of three things. One, determine the BOA rules preclude the submission of a second application until the first application is completely final. Two, determine that the second application fails the so-called Fisher versus Dover test. Three, hear the application on its merits and treat it like a new application.
Okay.
The follow-up? Sure.
Yeah, that was very helpful, and I just have one. I think if the board determines to proceed to hear this, which I'm not saying you have to decide, you can condition any determination that is other than no on the pending appeal being dropped. I mean, I think we can do that. In other words, I think the substance of the McCourt email is kind of like a stay is like a suspension. That's as good as saying there's only one thing pending before us.
I'll wait to hear from others before
Yeah,
I,
but I mean, that's,
that, my concerns about that. Mr. Ram?
So I'm still curious, what rule did you say that applies
is-
here? Because I didn't see the one that you referenced.
7 miscellaneous, rule number 4.
Okay. So it's one active application before the board at any time. And Ms. Casella, based off of what you just read, could you reread the first sentence that the Attorney McCourt said? Or the first couple sentences?
Yep. I agreed to stay the appeal, which is pending before the Housing Appeals Board. I did so with the agreement from Attorney Phoenix and Kaiser that they would only pursue one variance application to final approval. My reading of the Board of Adjustments rules indicate that the appeal currently pending before the Housing Appeals Board is no longer pending before the BOA, and therefore staff could accept the second application.
Okay, right. So application before the board is the key words here. Not somewhere in the process of courts, et cetera, but before the board. Thank you.
So,
I guess my thought is that the applicant does not currently have anything before the board. They are taking a case to the courts system, but that's not necessarily business that's before this board. We made a decision on their previous application, and that decision stands unless the court changes their mind.
and my concern with that is if the Housing Appeals Board overturns our decision, it comes back to us. We have perhaps an approved application from tonight and then another application that we have to deal with because the Housing Appeals Board, like the Superior Court, will not rule on it. They will remand it back to us, and that is my concern. And then we do have 2 active applications before us. So, my preference is that we wait for the appeal process to finish with the first application. But again, this is a board determination. Mr. Mano?
Okay, I agree with your assessment in that the Housing Appeals Board is going to either deny it or approve their appeal, in which case it's going to come back here. Then we have 2 applications. Is postponing this application indefinitely
Well, I think,
until the Housing Appeal Board makes a decision either way?
I think that probably the best thing to do would just be to withdraw it, which is why I did not read it into the record and have a public hearing on it. Just withdraw it, and then that way they are free to resubmit.
Okay, yeah, so withdrawal means there's only the one that's sitting at the Housing Appeals Board.
Yes,
Okay,
yes. Now, it
yeah.
is true under the statute, 677-9, I think it is, that an appeal does not have the effect of suspending the decision, so it still is a denial before this board. There is no doubt about that. My concern is if this gets approved, then we have 2
Two active applications, correct. Yeah.
As much as I don't like the idea of having 2 projects by the same applicant floating around, it seems that if we actually made a decision on this application tonight, we wouldn't have 2 active ones before us because this would be decided. And then in the event that, so the other one remains denied at this point, it would only become active if it got sent back to us, but at that point, this one would no longer be active. Because it didn't get sent back to us tonight.
Yeah, that is correct, but then we have a situation where an applicant is juggling their applications before this board. So,
we could address that when it comes up.
I guess, I'm not sure if it's before this board per se, or before the city, certainly. Now, the city the applicant would have two applications, and, we don't know if they're going to get approved tonight or not, but they would potentially have, not necessarily before this board, but 2 decisions by this board. I don't know.
mean,
I agree, it's an unusual situation.
it is, and I don't think there's any prejudice to the applicant to just waiting for the Housing Appeal Board. I think they do have a fast-tracked appeal process. I'm not sure, as opposed to the Superior Court. So I don't want to put us in a position where we have two sort of active applications. So, I don't know, Mr. Rayam, you've sat on this board for a long time. Has this happened before?
Not that I can recall, in my experience. But I guess the other oddity here is your proposal is that the applicant would withdraw, but that would have to be an action by the applicant. This board cannot force the applicant to withdraw. And then if they refuse to withdraw, then we still have an obligation legally to hear the application or take some kind of action on the application at this meeting, right? I mean, that could be a postponement.
We could do a postponement.
Right. But then that still leaves us in the same conundrum that we have right now, which is there's essentially two applications floating out there, one that we have not heard and one that is being heard by a court.
But if we postpone, it gives the applicant we could postpone with the intention that the applicant withdraw at the next meeting. I mean, I think this is highly unusual, and I was hoping you had some experience with this, Mr. Rayam, as to procedurally the right way to do this so that we don't, I don't know how the board's going to vote as to decide between these three options, but what is the best way to proceed?
I think we have to, it's almost like, first you have to consider, is hearing this permitted under the rules? Yes or no? Given the circumstances. Then, once you get past that, let's say you say it's okay. And I think we can make a motion on that. Then you'd have a question about whether this is, the current application presents a Fisher v. Dover issue, and that's a yes or a no. And then, assuming you get past Fisher v. Dover, which I think can go either way, then you hear the application. Like, I think they're serial, they're not like either or, if that makes sense. You gotta get to one.
Well, I'm just looking at Attorney McCourt's email where he said the BOA could do one of three things.
Right, I would say if Attorney McCourt were here, I'd challenge
Madam
him.
Chairman, can you ask the applicant if they're interested in withdrawing?
Well, I'm concerned because we're not in a public hearing, so I would,
You could read it into the record and open the public hearing.
But then the applicant can't withdraw.
yeah.
Oh, I mean, we're
Actually, may I add?
Yes.
So, just to review, the applicant has agreed in writing to only move forward with one application. As of right now, their past application is stayed. So there's only one application that's going to be heard. If this were to be approved, that would be their approval. The other one would still be denied. They have said that if they get an approval, they are not going to continue to go and appeal that stayed application.
Well, I think it probably would have been more proper not to appeal the first denial then,
Yeah, but
They had,
so.
I can understand why they did. But I think it's important to remember that, it's in writing that they're only going to be going forward with one, and we can't assume that they will do what they said they have not done, are going to do.
I agree.
So, Madam Chair, and Ms. Casella, weigh in if you feel differently, but I would like to make a motion to suspend the rules and allow the applicant's representative to discuss just this single topic before the board to provide that perspective from the applicant.
second.
All in favor?
Aye.
So I would need to read this into the record, hoping that I don't put the applicant in any peril. So the application is the request of Francis C. Mufluz Revocable Trust of 2015 owner for property located at 550 Sagamore Avenue, whereas relief is needed to demolish the existing structure and construct a 3-dwelling unit building which requires the following. Variance from section 10.440, use number 1.51, to allow a 3-dwelling unit structure where it is not permitted. Said property is located on Assessor Map 222, Lot 11, and lies within the Single Residence B SRB district. And who speaks the application?
Thank you, Madam Vice Chair. Tim Phoenix and members of the board. Tim Phoenix from Hopeful Phoenix, Gormley and Roberts on behalf of the owner and applicant. Thank you very much for opening the hearing to allow me to address this limited item, and I didn't mean to intercede on the board's non-public hearing discussion, but I thought I could help clear things up, so I'm glad it got to here. So I have done this many times. I don't know how many times in Portsmouth. It is not at all uncommon for a matter that's denied to be appealed to protect the rights while another, hopefully less impactful project is brought. And the reason for that is if I had not appealed the other decision, and then I came here before you and you said, we're going to invoke Fisher v. Dover, you can't bring this petition, I have nothing. So until you decide on Fisher v. Dover, the applicant and owner of the property is stuck. So we believe Fisher v. Dover should not be invoked. I also cleared this position, what we have done with the legal department before I did it, and was told by the legal department, because you're appealing, it's no longer before this board. I know there's been some discussion about that. It's in the court system. I fully respect and understand the concern of the board that that's pending, and if you deny this, I appeal, then two things are pending. But what I had told the legal department, as Stephanie has read, is that I had to appeal that decision in order to protect my rights to have a chance at bringing this one. So if the board finds that Fisher v. Dover does not apply and I can proceed with this one, then win or lose, this is what we will go forward with, and I commit to withdraw the other one. Now, I have to wait to see what happens with an appeal, because I don't know what neighbors are going to do, et cetera, and I don't want to be in a position where I have nothing. But one way or the other, only one will go forward. And so I would beg your indulgence to make the Fisher v. Dover analysis. I can't remember whether that's something you do on the submission or whether I argue it or not, but I'll leave it at that for this particular issue, as I was advised just to talk about this issue. If you have questions, I'll try to answer them.
Any questions from the board?
Would you be willing to withdraw this application tonight? Until the appeal is done?
No.
Okay.
Well, not yet, because that's a 7 or 8 month process. And I see no reason to do that. As I said, I've done this many times in various communities, both appeals to Superior Court, while you bring something that you think addresses the concerns of the board and the neighbors last time, and at the Housing Appeals Board. So if I withdraw, we're 7, 8, 9 months out before we could find out what's going to happen with that one, while I have, if you will, attempting to be before you something that I don't think anybody can deny that it's less impactful
Well,
than the last
you're
one.
getting
Yeah.
to the merits of
Okay.
the application, so.
Yeah.
Fair enough.
Yeah, fine.
So I would
Okay.
have to ask my client about withdrawing. We talked about it a little bit, but it was while you were talking, I was trying to listen and what have you. So what's the board's pleasure?
Well, I think maybe we can continue to discuss amongst ourselves, and perhaps you could just have a brief colloquy with
Okay,
your
thank you.
client. Okay. So I don't know if anybody else has, Ms. Record, is there anything that you want to add to the discussion?
I don't think so.
Okay,
I'm torn.
okay. Mr. Mattson?
Yeah, I would just add, one thing I don't think we should do is postpone this application, because that could result in having 2 applications in the future, even though the applicant has suggested that they won't do that. I don't see postponing as being the best choice forward.
Okay, thank you, Mr. Mattson. Mr. Phoenix, did you have any colloquy with your client? Yes. Mr. Ram?
I guess we'll get your question as the first.
Respectfully, we don't want to withdraw this. We think if we comply under Fisher v. Dover, we're where we need to be. We can present, and then whatever the decision, this is the one we would go forward with.
Okay, all right, thank you. So I think I'll close the public hearing, just so we can not take any more testimony. But, Mr. Ram?
Madam Chair, I would move that we proceed forward with this application this evening on the basis of Attorney McCourt's third recommendation that the board hear the application as would normally be presented.
And is there a second to that?
Yes, second.
Okay, Mr. Rayam, your motion?
Yeah, I mean, a lot of great discussion here. I understand the acting chair's concerns. I do share them a little bit. I think we have heard from the applicant's representative, and I think there is a good faith plan here by the applicant, and perhaps we can make that even more formal through part of any motion that we would make this evening that makes it clear that if in the event this passes the Fisher v. Dover, and if in the event that the board accepts the applicant and approves applicant's variance and approves it, that there would be a withdrawal of the other pending case before the appeals board. And I do think it makes sense in the sense that this really is an either or. It's not like there's anything complementary between these two applications. I suppose that the applicant could want to try and continue to say, hey, maybe I can get more out of my original application because it gives me more things. But I do think, my sense is this is a good faith attempt to try and rectify the concerns that both this board had and at least some of the abutters may have had, and we'll discover this evening if that is the case, and make our decision accordingly.
Anything to add for the second, Ms. Gephardt?
Yes, I would appreciate just clarification. What your motion is that the application, including an initial consideration of whether Fisher v. Dover is triggered, and then, depending on that determination, a possible determination of the application may proceed, and that it doesn't create an issue under miscellaneous, the rules miscellaneous 7 subsection 4. In other words, we can proceed, but we're not necessarily we're not saying anything about Fisher v. Dover, the application itself. This is really just a determination of our rules.
I would agree. It is a determination of our rules that this would not constitute a second application before this board. I would agree with that assessment, and that potentially Fisher v. Dover would apply.
Thank you.
So the motion on the floor is that we elect to hear the application on its merits and treat it like a new application. So I'll take a roll call vote. Mr. Mattson?
Yes.
Mr. Rayam?
Yes.
Mr. Mannel?
Yes?
Ms. Geffert?
Yes?
Ms. Rickard?
Yes.
And the chair votes no. I disagree. I think we need to have one application at a time.
Yep.
Understood.
So, anyway, I think that I would like to move to put that back into order here, to hear it in the proper order that it was tonight. So if I can get a motion from somebody to put that third on the agenda for new business.
So moved.
Second.
Okay. So we'll hear application in due order, Attorney Phoenix. So the first application here, and sorry for the delay, everyone.
The vote.
Oh, the vote. That would be helpful. No, everybody voted.
I made the motion, David seconded.
Oh, to move it back.
To move back.
Oh, to move it back. I'm sorry. All in favor of moving it back in the normal order of business?
Aye.
Okay. Sorry about that.
There we go.
Mr. Rossi is retaking his seat, and we'll proceed with the agenda as scheduled. So the first order, well, actually, before I start this, so for applications, the presenter is allowed 15 minutes unless asked for an additional 5 minutes and approved by the board. Those speaking to, for, and against the application will receive 5 minutes apiece. And so with that, we'll start with the new business. And the first one is A, the request of DSM MB II LLC owner and Bruno Fonzo applicant for property located at 1500 Lafayette Road, Unit 6, whereas relief is needed to establish a UPS store which requires the following. 1, a special exception from use number 7.30, consumer service where it is permitted by special exception. Said property is located on Assessor Map 252, Lot 2, Unit 6, and lies within the Gateway Center G2 district. And who is here to speak to this application? Please come to the podium and identify yourself and your address for the record, please.
Vanita Mohan, 8 Linwood Lane, Stratham, New Hampshire.
Okay, thank you.
I'm the owner of the proposed UPS store. I'm requesting special exception use under section 10.232. Market Basket Plaza located at 1500 Lafayette Road Portsmouth, New Hampshire, is a multi-tenant retail shopping center anchored by a Market Basket supermarket. In addition to Market Basket, there are 11 retail spaces that house a variety of retail, restaurant, financial, and consumer service uses. The Portsmouth Planning Department has determined that a special exception from the zoning ordinance is required for the UPS store, a pack and shipping store. The previous tenant was Supercuts Hair Salon that vacated in mid-2023. This is for a special exception under Section 10.440 of the zoning ordinance to permit a consumer service use according to the Planning Department. The proposed tenant, the UPS store, is an ideally suited use for this type of shopping center. The UPS store will have one space for delivery trucks adjacent to its rear door. There will be no unusual noises, odor, or impact from the proposed use. It will offer convenience to the existing customers of the multi-use shopping center. The owner respectfully requests that the Zoning Board of Adjustment grant the requested special exception to allow the tenancy of the UPS store. The proposal meets the criteria for the necessary special exception. Those criteria are set forth in the ordinance at 10.232.20. 10.232.21 zoning compliance. The property complies with the standards outlined in the ordinance for special exception uses. Zoned for commercial use, it's an ideal site for the UPS store, aligning with zoning regulations. 10.232.22, ensuring public safety. The proposed use can be operated safely. The premises and the operations it will host are designed to be free from risk of fire, explosion, or the emission of hazardous substances. 10.232.23, local impact considerations. The operation within Market Basket Plaza will not harm property value or alter the fundamental character of surrounding residential, commercial, or industrial areas. 10.232.24, traffic and parking. The business will not increase traffic congestion as it is located within a complex with ample parking space of 387 spaces. All truck pickups and delivery will happen at the rear side of the building, causing no disturbance to the shopping customers. 10.232.25, conservation of municipal resources. The proposed pack and ship will not place undue burden on municipal utilities and services. There will not be no adverse effect on the water supply, sewer system, waste management, emergency services, or educational institutions. 10.232.26, effective stormwater handling. The operation will not result in any increase in stormwater runoff affecting neighboring properties or public thoroughfares. There will be no change to the building footprints or paved surfaces. For the foregoing reasons, the owner respectfully requests the board to grant the special exception as requested and advertised. Thank you.
Thank you. Are there any questions for the applicant? Seeing none? Is there anyone here who would like to speak to, for, or against this application? You may take your seat while we take public comment. Thank you.
Thank you. Good evening.
Good evening.
I'm John Matthews. I'm the owner's representative for DSM MB2 LLC, the owners of the shopping center. I've been involved with this particular property since it was built in the mid-90s. Have handled most of the leasing here. We have 11 specialty tenants plus Market Basket. We've had a lot of turnover in tenancies over the years, and I don't think we've ever been before this board for a special exception. I understand there was a change in the zoning at some point. I think the most important thing for me to say is that the Parcel Room was a longtime tenant in this center, so this use has been at the center. We know what it will do. We know it will be a good use for the customers. It's our tenant mix very nicely, and I'm urging the board to grant the special exception. Thank you.
Okay, thank you. Is there anyone else who would like to speak to, for, or against this application? Seeing no one rise, I'll close the public hearing. And we'll wait a motion.
I would like to make a motion to grant the special exception.
And do I have a second?
Second.
Mr. Rossi, your motion?
Just a second. So this is a use that is allowed in the zoning ordinance by special exception, so it satisfies the criterion of 10.232.21. There is no hazard to the public. This is a simple operation that's very consistent with other operations that are currently ongoing in that shopping center and have been in the past, with no hazard presented to the public. No detriment to property values, as evidenced by the fact that the representative of the property owner feels that this would be a good use within this facility and is consistent with the uses that they're trying to foster there. It is also not representing a change in the essential characteristics of the area. Across the highway, there's a FedEx facility in a very similar shopping center in very close proximity to this, so it's certainly within the character of the neighborhood. There's no creation of its traffic safety hazard. This is normal consumer traffic, which should fit in really without much notice or impact at all on the high volume of traffic that goes in and out, particularly for the Market Basket and some of the other facilities there. It's kind of located far enough away from the Market Basket that I don't see parking as being particularly problematic for the use of this store. And I see no impact on municipal services, so 10.233.25 is satisfied, and there's no change in the building structure. Therefore, there's no impact of increase of stormwater runoff onto any adjacent properties, and therefore 10.232.26 is also satisfied.
Thank you. Anything for your second, Ms. Guilford?
No, thanks.
Okay, I'm ready to take a roll call vote. The motion is to approve the special exception as advertised and presented. Ms. Rickard?
Yes.
Ms. Geffert?
Yes.
Mr. Mannel?
Yes.
Mr. Rayam?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes. It passes 7-0. Thank you. Do I do that then?
If you want to.
Show authority up here.
Have fun with it, you know?
The gavel is addicting.
Yes, it is. I have power. Okay, so the next item on new business is B, the request of Timothy S. Wheelock and Susan V. Denenberg, owners, for property located at 414 State Street, Unit 2, whereas relief is needed to convert a ground floor commercial unit to a residential unit, which requires the following. 1, a variance from section 10.642 to allow a residential unit on the ground floor where non-residential is required in the downtown overlay district. And 2, variance from section 10.5A41.10A to allow 806 square feet per dwelling unit where 3,000 square feet is required. Said property is located on Assessor Map 116, Lot 13, Unit 2, and lies within the Character District 4L1 and Downtown Overlay Districts. And who is here to speak to this application?
My name is Tim Wheelock, and I'm here to speak to the application as a joint owner. It's Tim Wheelock, not Tim Phoenix, so I wouldn't be able to speak at the level you were discussing the common law earlier with Attorney Phoenix. But I did practice law for 32 years in Portsmouth, but as a family law attorney, personal injury attorney, and guardian ad litem, not in land use. I'm very familiar with this property. I was first connected with it in 1996. I rented from an attorney named Jeff Crompton and purchased a half interest in the condominium that I'm here to speak about today in 1997. I moved out in 2007, but purchased the other half interest in 2007 and then transferred the ownership into joint ownership with my wife. So about 28 years of familiarity with the property, 27 as an owner, 17 years of attempting to rent it out as a commercial property, and I'll speak to the problems that have developed in that regard. It's a building that I always understood was circa 1800. It's a historic building. It was once a single-family residence, originally the home of Abram and Rachel Isaacs and their son. It was converted to condominiums in 1987 by Josephus Brewster. And it currently consists of 5 condominiums. All the other condominiums in the building are currently being used for residential purposes. There is a parking area with limited common area parking spaces for 4 vehicles, and parking space A is a limited common area assigned to Unit 2, and that will not change. On the first floor, Unit 1, which was combined with what had been Unit 5, is currently being used for residential purposes. The second ground floor condominium is 2, which has traditionally been used for professional or office purposes. And then there's 2 units on the second floor and 1 on the third floor. All of those are commercially being used for commercial purposes currently. And what has happened is, and I'll mention that when I did move from 414 State Street, I moved my law office, it was 753 square feet. I purchased a unit at 600 square feet that was at 600 State Street that was almost double the size, 1,500 square feet. And the size of the unit is relevant to today's discussion. It's in a historic building. That's a plus in many respects. It's a negative in some, insofar as its commercial use. It's too small to allow for adequate separation for professional use where confidentiality is required. There have been complaints by the other condominium owners about the amount of traffic that was generated when it was most recently used as a therapist's office with 2 therapists occupying the unit at a time. There's been complaints about the amount of traffic, complaints about the signs swinging back and forth, complaints about customers hanging out in the hallways, complaints about clients hanging out on the front steps, et cetera. So it's been increasingly, as after I started running it, it's been increasingly a source of tension with the other residential unit owners. My wife and I are now both retired. We can't use it as a office condominium. With the advent of COVID, one of the things that has changed is, and it was always a bit of a hard sell because it was so small, but with the advent of COVID, if I speak with prospective tenants who are perhaps a solo or maybe 2 people, which would really be all that's suitable, they would prefer to work remotely and perhaps use an office center for meeting with clients. So in that sense, everything's changed. I was receiving no complaints, for example, from the other residential tenants during COVID when the therapists were working remotely, because then the traffic issue and so forth was not present. And then I think it's relevant that it was the Counseling Center of Nashua, they left in order to rent larger commercial space. We could make use of it for family purposes, for a residential condominium. Insofar as the downtown overlay district, my understanding is that the intent of the zoning ordinance is to ensure that there are pedestrian-oriented businesses along the streets and to allow retail business to thrive based upon foot traffic downtown. So this is an area on State Street in Portsmouth where there is virtually no retail activity other than the library restaurant across the street, and none on the side of the street where Unit 2 is located. There is one building housing a number of therapists next door, but again, the residential condominium owners in 414 State Street have persistently complained about such use. The public does not generally shop in this area, and the structure of 414 State Street does not lend itself to retail use, even if there were no objections from the residential owners. If you just look at the front of the building, I think you'll see why I say that. It looks like what it is, which was once a single residential building. I want to speak to the variance requirements. Granting a variance will not be contrary to the public interest, which would maintain, if it were granted, the overall reality of the mixed use in this area, which abuts Court Street, which is a mixed residential office zoned area. The spirit and intent of the ordinance would be met by granting the variance. It certainly is within the spirit of the ordinance to allow the owners to use the unit in the same fashion that it was originally intended for residential purposes. The first floor residential use of Unit 2 would not change the essential character of the neighborhood. There would be no external changes to the building. There will be no structural changes to the interior of the condominium beyond adding a small kitchen and shower. And I am endeavoring to, in this process, restore and preserve the historic features in the unit, some of which were previously water damaged, including the plaster walls and crown moldings and the original woodwork. The building was a single-family residence originally, and allowing the variance would allow the building to once again be used for those residential purposes. All the other buildings on this side of State Street, with the exception of the therapist's offices, one building housing an architect, and some other small offices at the intersection with Middle Street and the library restaurant across the street, appear to be residential from just walking the neighborhood. And so granting the variance would not make any substantial change in the character of the neighborhood. There's no draw for foot traffic in the area, except for the appointments at the therapist office and the library restaurant. And accordingly, permitting residential use on the first floor will neither alter the essential character of the neighborhood nor threaten the public health, safety, or welfare. And granting the variance will not diminish the surrounding property areas. I included an opinion from a realtor who said that converting it would increase the value of the condominium, and hence I would infer the value of the building and the neighborhood. And again, there are special conditions that exist that distinguish this property. 414 State Street maintains many of its original characteristics that it had when it was built in 1800. Several of the original rooms in Unit 2 are essentially intact. None of the retail establishments that the downtown overlay district is intended to protect are present in this area. It's very similar again to the abutting mixed residential office district. The dynamic of the property is distinguishable from the vast majority of the downtown overlay district. And so I would conclude that substantial justice would be done by granting the variance. Any other factors I wanted to mention? that pretty much, I'm sorry, sums it up. In terms of the requirement that,
Attorney Wheelock, I just want to interrupt and say that you have about 3 more minutes left, and you haven't touched on unnecessary hardship.
well, the
Explicitly.
necessary hardship is that it cannot be used for retail purposes without drawing the objections of the fellow owners. Cannot be, there is actually a requirement in the bylaws that it cannot be leased for commercial purposes that would conflict with the residential nature of the rest of the condominiums. And what I'm telling you is that I'm drawing increasing complaints that the uses that it has been put to are in conflict with the residential nature of the other units, according to at least a couple of unit owners. So I'm in a position where I can't lease it at a rate that is sufficient to meet the overhead for commercial purposes, if I can lease it at all, with the permission of the other residential unit owners. So that's the hardship. It's born out of the nature of the condominium unit itself. And having worked there, I can say that it is not appropriate for professional office use for more than 2 people at a time. Again, because of the lack of separation and confidentiality concerns. I did want to speak very briefly to the requirement that the lot area per dwelling unit be 3,000 square feet minimum. You know, the building itself meets that requirement. The condominium obviously doesn't, nor would any condominium in the downtown overlay district meet that requirement. And it's born out of the historic nature of the building. That's what I have.
Okay, thank you. Any questions for the applicant from the board? Mr. Ram?
I don't have a question, but just to state for the record, the petitioner's exhibits 3A through 3 something or other are all form letters. They're addressed to Chairman Rayom. I haven't been the chair for over 2 years, so I just wanted to state for the record that that was not entirely correct. The one I am disappointed with is Exhibit 3E, which is from Attorney Bozen, who I would have thought would have known better. But
He had a bad week last time.
I'm not sure he saw it as directed to you, but perhaps he did. I don't know. Again, I'm Tim Wheelock, not Tim Phoenix.
Any other questions? Okay, if you could please sit down. Is there anyone here who would like to speak to, for, or against this application? No one rising? Okay, with no one rising, I will close the public hearing and await discussion and a motion from the board.
I think this variance request is reasonable and well justified by the facts presented. That's my comment.
That sounds like the beginning of a motion.
I'm willing to make a motion unless somebody else feels like they would like to state something to the contrary. Okay, I move that we approve the variance application as presented and advertised.
Second.
Second, and your motion, please, Mr. Rossi?
Okay, granting the variance would not be contrary to the public interest. Right now, the public interest in Portsmouth is not one which is crying out for additional office space, but is really looking for additional residential space. So by allowing this unit to be used as residential rather than office space, the owner is actually acting consistent with the public interest. Granting the, and that also takes care of the spirit of the ordinance, because those two are considered together. Granting the variance would do substantial justice. There is no loss to the public that has been presented to this board, which would justify depriving the owner of this use of the property. and therefore that criterion is also satisfied. Granting the variance would not diminish the values of surrounding properties. The only evidence that we have presented to us today is that there would have, if anything, a positive impact on the value of surrounding properties. And then the final criterion, literal enforcement of the provisions of the ordinance would result in an unnecessary hardship, and that relates to special conditions and circumstances of the building. And we really are considering two variances here. One is the use variance for residential, and the other is the square footage variance, which would normally require 3,000 square feet per dwelling unit. Therefore, the special conditions of the property must relate to both of those. In the first instance, in terms of the use, I agree that the intended purpose of the ordinance is to encourage pedestrian-oriented businesses within the overlay district. And since there really is a dearth of such businesses in this area, we're really not violating the spirit of the ordinance, because it is consistent with the character of that immediate surrounding neighborhood that such uses are really not prevalent. With regard to the 3,000 square foot per dwelling unit requirement, the special condition of the property is really the historic nature of it, the antiquity of it. There are really no reasonable options for expanding the space from the unit to achieve a 3,000 square foot footprint, and therefore that is a special condition and hardship that speaks in favor of this application, and I find that this criterion overall is satisfied.
Okay, thank you. And anything more from the second, Mr. Rio?
Yeah, just to double down on a couple of things that Mr. Rossi said. I do agree that the applicant has made a good case here that the immediate surrounding properties really don't reflect the concept that's put forward for the downtown overlay district of having this sort of active street life, which really in practice doesn't always work anyway. We've seen a lot of times where buildings are built with in such a way that really there's only entrances on one side and people are really walking down almost like a blank wall by the time you're done. So it's not always effective anyway. I think in this particular case, it is absolutely true. This feels far more residential than other parts of the DOD. It's very similar to a case we had a few years back on Chapel Street as part of the reconditioning of the Connie Bean Center. There was a new purely residential structure that was built as part of that. I think there was a good argument that that portion of Chapel Street, even though it is in the downtown overlay district, really just had no businesses on it. I think there was like a candy store at one point in time, and that was about all that has ever been in there. So I think that makes a lot of sense. I really think that speaks to the first two criteria that really looks at the characteristics of the neighborhood, and I think in that sense this is very much in keeping with the characteristics of the neighborhood. And then in terms of the lot area per dwelling unit, as Mr. Rossi pointed out, it is an existing structure. To me, the real change there was in 1987 when it was condoized and broken up into the 5 components that essentially made the lot area per dwelling unit or lot area per unit of the condo a fixed entity. And although 3,000 is required, the current is 968, reducing down to 806, which is not that substantial of a change, and in both cases was going to be below what is required for the area. So I think it is a reasonable request and does reflect a hardship based off of the fact that it was subdivided back in 1987. That's all.
Anything else from the board? Okay, so I will say I will be supporting this. I have been pretty vigilant in the past about the downtown overlay district because for the reasons that Mr. Rossi and Mr. Rayam said, they're very important for the economic vitality of the city, and that is a very, very intentional zoning provision. It does say that ground floor in the DOD shall consist entirely of non-residential. Another one of my questions to Chair Eldridge and to Steph yesterday was the unit 1 is residential, and that's a pre-existing non-conforming use. So I think that is really the hardship. So I will be supporting this application. So if anything further, I'll call the vote. Okay. I'm going to start this end. I'm going to alternate. Mr. Mattson.
Yes.
Mr. Rossi.
Yes.
Mr. Rayam.
Yes.
Mr. Mannel.
Yes.
Ms. Geffert.
Yes.
Ms. Record.
Yes.
And the chair votes yes. You have your approval. Thank you. Okay.
It's easy for you. Steph has to record the votes. So.
I know. She didn't have the sheet, though. Yeah, move along, Steph. Keep up. We'll let her keep up while I call the next application. Next item of new business is item C, the request of Francis C. Mafluz Revocable Trust. I apologize if I've said that name wrong. Of 2015 owner for property located at 550 Sagamore Avenue, whereas relief is needed to demolish the existing structure and construct a 3-dwelling unit building which requires the following. 1, a variance from section 10.440, use number 1.51, to allow a 3-dwelling unit structure where it is not permitted. Said property is located on Assessor Map 222, Lot 11, and lies within the Single Residence B District. And for this application, Mr. Rossi is again recused. And Attorney Phoenix, could you please present your application?
Thank you.
Madam Chair, point of order, do we want to consider Fisher v. Dover prior to?
That's what I was going to start with, but.
Well, I figured I would have Ms. Attorney Phoenix start with the Fisher v. Dover.
Okay.
I believe that's what you were intending to start with.
Yeah, I was going to introduce everybody and then ask how you want to proceed with it. So I'll just do that.
Okay.
Madam Chairman, Vice Chairman, members of the board, Tim Phoenix from Hopeful Phoenix, Gormley and Roberts here on behalf of the applicant. I'm here with Ted Alex, who's the applicant's son. His sister Patty Cameron was here last time, but this time is not here. She may be watching if there's a way to do that. They had a previously scheduled vacation this week. I'm also here with Eric Weinrib, whom you know from Altus Engineering, who's done the design work, and Brian White from White Appraisal, whose appraisal is attached. And walking in late are the architects, Mark Giannini and Richard Desjardins. I know from speaking to Steph the past couple of days that Ms. Margison had some questions about what the plans showed or what the numbers meant. They're here. They can answer those questions if you like. So turning to Fisher v. Dover, I'd ask the board's pleasure. I don't remember whether you want to just discuss this on your own or whether you want me to present it. It's pretty well laid out in my submission, but so how would you like?
I think if you could briefly present it, and
Okay.
then we'll discuss it and decide amongst ourselves.
Sure. So as was discussed a few minutes ago in the at the beginning of the hearing list, we were here back in October with a different, what I would call more impactful project. If Steph, if you can go to Exhibit C. While she's doing that, that'll be the site plan review of, you just pass it. So that's the proposal we were here for back in October, 4 units in 2 duplexes. You can see that the units cover about half of the lot, with the back half of the lot being open and wooded. So that was denied, as mentioned earlier tonight. That's on appeal. And repeating for the purpose of this record, the reason we had to appeal it is because if I didn't appeal that and you find that Fisher v. Dover does apply, and therefore that I can't proceed, then I would have nothing. So I'll again reiterate that if we get by Fisher v. Dover and get into the merits of this, our intention is to we'll go forward only with this project and withdraw the other one. That's an agreement I've made with Attorney McCourt. So there's 2 ways that you can bring a new application after an earlier application is denied. I've cited the case law. I won't go into that. The first is that there's got to be some kind of material change, significant change in the application. The second is when the change and new application has been implicitly or explicitly invited by the board and or members of the board, and we think we have both of those in this case. For instance, on the former, the changes, we've reduced the number of units from 4 to 3, which is a 25% reduction. We've got 1 single structure instead of 2 freestanding structures, which reduces by 1 the number of variances that we previously sought. So we're only looking for 1 variance now, which is the 3-unit building in this zone. We've reduced the number of arguable vehicle trips by 25% because there's 1 less unit. We've increased the wooded buffalo to Walker Bungalow from 177 feet to 283 feet. If you could bring the current plan up, Steph. We've increased open space by 2,363 feet to 80.6, which is double the 40% required. We've decreased building coverage by approximately 1,474 feet to 9%, which is less than one half of the permitted 20%. We've decreased density from 1 unit per every 15,688 square feet, where 15,000 is what's required under the ordinance, to 1 unit for every 20,918 square feet. And we've preserved the streetscape, Exhibit B, by providing a single-family home look. Oh, keep going. There it is. So there's what the property is going to look like from the street. It's a classic New Englander big house, back house, little house, back house barn. That's the feel that we were going for. You may recall that Mr. Rayon mentioned at the last hearing that perhaps something could be done here, maybe not 4 units, and he mentioned a project I worked on 8 or 9 years ago over on Broad Street where we had something similar. 4 units were requested. That was denied, and we came back with 3, and it was approved. Comments made, I just mentioned it by Member Rayon, was that perhaps more than 1 unit could be approved, but maybe not 4. Member Margerson observed that the project looked like a complex with a lot of parking, so we've tried to address that. So, driving by, you're going to see what looks like a colonial house, and then going to the back, would be the back house barn area, which would be 2 more units. I've also included in the Fisher v. Dover analysis of my submission on page 4 other applications, including the one at 482 Broad Street for Paul Burton that I just mentioned. In 2016, 2019, I represented Tuck Realty for 23 townhouse units. That was denied, and we came back with merged lots and reduced the number of units to 18, which was a 21% reduction that this board said could proceed under Fisher v. Dover. We had, this was not mine, Susan McDougall to reconstruct and expand a 1-story addition at 39 Prey Street. The board saw it fit in 2017 to grant let the second matter proceed. There's an application of Neela LLC to redevelop an existing garage as a dwelling unit. There were previously denials, but it was the final application was found to be able to proceed under Fisher v. Dover. So, and then I represented Jeff and Melissa Foy in 2022. Most of you were probably on the board. It was down by the water. We had essentially a 2-bay garage added on. That did not pass. Over concerns of the board and the members, we reduced the size of that by approximately 50%. 1 bay was taken off, leaving more open space towards the water, and the board saw fit to let that second one proceed. So we think that under the circumstances, we have both instituted changes that are materially different than the matter that was denied last October, and based upon the comments of some board members, was explicitly or implicitly invited. And we think we have listened to the concerns of the neighbors. We've listened to the concerns of the board last time. We've come up with this project, which we hope you will allow us to proceed on.
Okay, so I'm going to ask at this time for any discussion by the board or about the Fisher v. Dover analysis, or anyone want to invoke it. So I would just, at this time, ask the board for their thoughts, comments, feedback.
Good.
Okay. So affirmatively, Fisher v. Dover is not being invoked by the board, so you may proceed with your application.
Thank you very much to you and the board members. I appreciate that on behalf of my client. We've gone into most of it. Steph is showing you right there the look. If that's an oblique look, as you know. Just want to make sure of my time. I'm hoping I get 15 minutes from now.
Yes.
Thank you. There was concerns expressed by the neighbors and the board that there were too many units, that the layout of those two duplex units sort of catty corner to each other, which were all units clearly visible, was of a concern, as well as the coverage of the lot, et cetera. So we went to the drawing board, and Mark and Richard have designed this for us. which is, as I said, is a colonial look from the front. It's going to fit in with the neighborhood, we believe, because it'll be hard to determine that there is there are multiple units there. If you can go back to Exhibit A or 1, whatever it is, A. So right there, so you can see this is the 3 units on a site plan, and you can see that in the previous application, the building coverage went back to about 50% of the lot. Now here we're about 1/3 of the lot. So we are preserving approximately 2/3 of that wooded area, which we weren't doing before. The other thing, and Mr. Mantle mentioned it at the last hearing, that we could conceivably do a 3-lot subdivision with a road and 3 standalone homes. So if you can go, Steph, to Exhibit J, it's the last one. This was also in the last submission. It should be a site plan. Yeah, that looks like it. So this was Eric Weinrib's identification of something that we could potentially do on the lot. It appeared to meet requirements and require no variances. We would obviously have to get planning board approval, but you can see there will be, in doing this, there would be a sea of pavement with that big turnaround, and the back 2 lots, maybe not all of that wooded area, but a significant portion of that wooded area would be eliminated in order to put the houses on those lots. So we have a large lot that's essentially 4 times, a little more than 4 times the minimum lot size in this area. We don't want to do this for aesthetic and financial purposes, economic purposes. We don't think the neighborhood would want this. We don't think the board would want this. And we can accomplish the same functionality, so to speak, by what we have proposed. So if you can go to Exhibit H, which is the tax map, right there. So as I said last time, one of our arguments in support of the relief that we sought then and seek now on a lesser basis is that you can see our lot is outlined in green. There are several lots of similar size near us, but within a 0.2 mile radius, distance up and down Sagamore, there are many small houses on very small lots that if you added them up to 60,000 square feet, the density would likely be more than what we're proposing here. Right next to us is a relatively small lot. 2 away from us, going towards Rye, is a relatively small lot. If you keep going down, it's on and off the yellow. There's a bunch of other very small lots with homes on them. So if you consider the neighborhood as a whole, as opposed to just the houses that are right next to us, our density fits in. And under circumstances where you really won't see, you really have to be looking for the extra units, we think it meets all of the requirements. If you would go, Steph, now to the GIS map. The other thing that we brought up last time, and we still think applies here, is that we are in a area that has a confluence of different zoning requirements. We've got SRA, SRB, which we are directly across the street at Tidewatch is SRA. There's the garden apartment zone, essentially directly across the street from us, and I can't see the other one. GRA a little further away. So you've got different zones all coming together in nearly one location, but certainly in close proximities that have differing lot size requirements, differing lot size per dwelling unit requirements, differing permitted number of units per area, et cetera. So we think that's the neighborhood. I know last time there was some comment by some neighbors that our neighborhood is only our zone. Well, that has not been my experience in Portsmouth. I have on numerous occasions been before this board with areas where you're kind of in a transition from one to another. So we think that we clearly meet the requirements of fitting in. At the top of the hill, just as you crest the hill to go down over the water towards Rye. There's a 3-unit there now. It's 4 or 5 buildings up from us, away from us. And that is more intensive because the cars park right on the street and back out into the street. We've got across the street that where the Lester King was that was approved. I know Ms. Margison pointed out incorrectly so that the difference there was that was a non-permitted use in that property, and we've made it sort of more conforming. But the fact is that the board saw fit to permit multiple standalone dwelling units on one lot. So that's the history. I won't belabor that part anymore because I went through it before. Again, the real facts are same area, better lot area per dwelling unit. It exceeds by 5,000 square feet per dwelling unit what the area requires. The big concern was the look of those buildings in 4 units. We've addressed that by the single look from the front of a colonial with everything else tucked behind it. So turning to the variance requirements. The first 2, as I always do, are that the variances are not contrary to the public interest and the spirit of the ordinance is observed. The Supreme Court has considered those similar, and since the Malachi Glen case that I cite we've considered them together. As I always do, I go through the purposes of the Portsmouth zoning ordinance. It's outlined in my submission on page 7. I won't repeat all of those. But the bottom line, the underlying test of those 2 is, will granting the variance alter the essential character of the locality or threaten the public health, safety, or welfare? Starting with the latter, we have a 1960 vintage home, single-family home, which probably wouldn't meet code. Whatever we build here is going to meet code. We think it's going to protect health, safety, and welfare as well or better than a 3-unit subdivision with a cul-de-sac and a sea of pavement. So the public health, safety, and welfare is protected by granting this variance. And the second is whether it would alter the essential character of the locality. As mentioned, the character of the locality is what I've called eclectic. You've got apartments, a large apartment complex, condominium complex, single-family homes on large lots, single-family homes on medium lots, and nearby you've got single-family homes on very small lots, the density of which, if you added them up to 60,000 square feet, would likely be more dense than what we're proposing. So we think we've met those 2 prongs. The third of the 5 tests is that substantial justice will be done by granting the variance. And the test under Harborside is if there's no benefit to the public that would outweigh the hardship to the applicant, this factor is satisfied. And under Malachi Glen, that's the Harborside case, any loss to the applicant not outweighed by a gain to the general public is an injustice. So we're proposing to remove a dated single-family home with a very wide curb cut at Sagamore in favor of a much narrower curb cut, fewer units in a single structure inspired by a New England farmstead. We're preserving a significantly greater wooded area that's benefiting the neighbors to the behind on Walker Bungalow, and is for members of the public. The revised project appears, if you're just going by, as a large single-family home, big house, little house, back house, barn. Only one of those is missing since there's only 3. Because of these changes that we've made based upon what we learned at the last hearing, there is no danger or detriment to the general public from granting these variances. Yet denial will deny the Mafluzis and Ted Alex and his family the right to develop a large parcel of property under circumstances where we know housing is needed, even in expensive Portsmouth. Housing is needed here and throughout the state. Gary Cameron, Ted's brother-in-law, submitted a letter with some citations to the housing needs. We just think this is a very good project. Another option, if this didn't go through, is some kind of estate, in the middle of it, which could be larger yet. So we just think this is a fair proposal in light of the circumstances and the area in which this is located. Number 3 is that granting the variances will not diminish surrounding property values. Well, I got my numbering off, but anyway, you have, Brian White is here. He wrote an opinion last time that the more impactful project would not diminish surrounding property values. I did not have him reissue it because it follows, and he would testify if he's asked, that if that project didn't diminish surrounding property values, then a smaller project with a cleaner look won't diminish surrounding property values. And the final prong, unless I missed one, is the hardship test, 3 prongs. First, is there's special conditions that distinguish the property from others in the area. As I've mentioned, this property is 4 times the SRB lot size. Its frontage exceeds the requirement. The depth of the property is 3 times its width, so it's long and narrow. And because of those factors, it's hard to reasonably put a regular subdivision in there, nor would the cost, economic cost of it justify it, given the amount of land you'd have to use. Those factors, we believe, constitute, in combination, special conditions. The second prong is that there's no fair and substantial relationship between the public purposes of the ordinance and its application here. So why do we have these? We have limitations on a lot area per dwelling units, and that and number of units in a dwelling unit in order to provide separation from neighbors, air, light, stormwater treatment, sight lines, and what have you. And if this lot was square, essentially, you might get 3 lots next to each other up and down the street. But since it's not, or if it was flipped, you could probably do that. But based upon its size, yet shape of long and narrow, it's difficult to do that. And we think it's fair and reasonable to put 3 units on here. So we don't believe that we violate any of the purposes of the zoning ordinance with respect to not permitting a 3-unit building, especially where there are multi-unit buildings nearby. The final prong of the hardship test is that the proposed use is reasonable. This is a residential use in a residential zone, so the use itself is reasonable. I just want to check that I skip one. Either that or my numbering's off. My numbering's off, so I don't know if any of my team wanted me to add anything. We're here to answer your questions. Anybody? They're not moving, so that's all we have, subject to your questions.
Okay, thank you. Questions from the board? Mr. Ram?
Thank you, Madam Chair. So looking at your plan that is currently up on the screen there, just trying to understand what your team's thinking was. And so the situation that you have on this lot, the 2 neighboring properties, one at 546 and the other at 576, the existing house at 546 is, very close to the property line, about 5 feet. The other neighboring property, even though it's a very large lot, I think maybe even bigger than your client's lot, the house does happen to be like right up against, 10 feet away from the property line. What was the thinking in terms of positioning of the new structures, and in particular for the new barn structure, which really is at the heart of the additional relief you're asking for, right? You want those 2 additional units. You're kind of hiding it in the barn structure, but positioning of it, it is relatively close to that property line. What was the thinking in terms of the options that your team had, and why you ended up where you're at?
So I'm not sure I can answer that alone.
Yep.
I'll start. One of the
You're allowed to have the call line for help if you need.
I'm not Tim Willock, by the way. One of the issues is the closeness of that house at the bottom there, that's almost right on the lot line. We wanted to give that some space. I guess I would turn it over to Eric and the architects to see if there's any site issues, or whether there's possibility of movement.
For the record, Eric Weinberg with Altus Engineering. There was part of the discussion in figuring out where to put that driveway was trying to follow in general sense where the existing driveway was. That was a little bit of one of the parameters. But the other was to make sure that we honored more than, because the other property is right up against the property line, we figured, well, give them their setback plus our setback for the space in between our development areas. So that's where our thought process was with it. whereas on the other side, it's almost meeting the setback. So we wanted to kind of balance the space, the open space between the houses and the development area on each. Could we move it further north, closer to the house on the other side? Yeah, there's some opportunity to do that, but we just kind of balanced it by keeping it the space between the buildings, if that makes
And
sense.
just as a follow-up, so the depth relative to the street, where you positioned it there, I mean, I guess you are past the end of the existing house, but not by much. Was there any discussion or thought about, putting that a little bit further back? Understanding you're also trying to preserve the wooded area, so you're balancing some concerns there, but I'm just trying to understand what your thinking was.
So we tried to push it as far forward as possible. I personally like my initial layout where they were skewed and but I'm not going back down that road. But one of the things we heard from this board was follow the street line and move the houses up forward. So that's what drove us up forward. And, we were moving it as far forward as reasonable. One of our initial design concepts was more like that property on Broad Street, where actually, I believe there's a house, the garage is straight in, and then you go around on the side, and I felt like that that garage was too much in your face, so we wanted to put that front house with the side load garage rather than staring at a garage. I personally don't like seeing garage doors when you drive by a house. I think it creates a better aesthetic, so that also pushes it to one side more than the other so that you can come into the driveway, turn, and get in there. And going back to the original house, there really isn't an opportunity at that house to back up and turn around on the property. You're kind of into the edge of the right-of-way and so forth. Have I answered your question?
I did, Madam Chair, if I can just have one more follow-up. So, your parking requirement is actually only 4 spaces according to the report by the city staff. You're going to be providing a lot more than that. Is the spaces, is there intent to provide parking spaces in front of the garage for Unit 3? Is that also one of the factors that drove the positioning?
That's part of our parking, is so that you have 2 spaces in each unit.
Mm-hmm.
So that exceeds your parking requirement. And then you have your visitors, everyone has the ability to have someone park behind each bay of the garage. So that's why we have so much parking. We're not creating, what I'd say, parking stalls. They're just parking areas as part of the driveway maneuvering area.
Okay. I'm good, thank you.
Okay, thank you. Anyone else? Okay. I have a question for Attorney Phoenix. So the size of the lot is quite large. It is 62,000. And the lot area per dwelling unit we have down here is 20,918. But the portion of the lot that is buildable is but a portion of that. You say it's about a third. What is that again specifically? How many square footage of the lot are being built on?
Okay, there's a difference between our buildable and our being built on. You said both, so I pretty much, other than ledge, maybe the whole lot is buildable. I would have to ask Eric if he can give us at least a rough number for the square footage of the area that's being built upon. And Madam Marston, do you want just where the buildings and parking are, or do you want the light green area?
Light green area too, please.
He's calculating.
Okay, no pressure. So my other question to you is, I recognize the desire and want to get everything you want out of this land. I absolutely do. And of course, we need more housing. However, what we are tasked with dealing here on the ZBA is hardship. Where is your hardship where you cannot build a single residence home on this lot?
Well, I think that you have to kind of consider hardship, given the circumstances of this lot. It's kind of reverse. It's in our opinion, the hardship is how large the lot is. And I got to cheat a little and go back to my submission. It's, when people say the word hardship, you think of, what's wrong with the land. 25 years ago, before the Simplex case and its progeny, the hardship test was a lot harder to meet. But now, the question is, are there special conditions? And we believe there are special conditions because this lot is 4 times the required lot size. I know, and I said that there are some lots that are that large near us, but there are a number of lots that are much, much smaller, within 0.2 of a mile. So in considering its overall environment, when you have a lot that's 4 times the size of the lot, why would we want to have somebody buy that and put up a McMansion that's going to cover just as much area when you can provide, if you will, I don't want to use the term affordable because it's not affordable as defined, but relatively more affordable than if you're likely on Richards Ave or somewhere down in that area. The depth of the property is 3 times its width. So as I mentioned before, if you had a square or a rectangle turn going up and down the street, you probably could put these 3 units in 3 separate units without any problem. We then compare it to what do you have to do if you meet the requirement of the ordinance, which is not to put one house on that lot, but it's to create a subdivision to allow the 3 houses on the lot. And we just think that makes no sense whatsoever. So we think if you consider the size of the lot, the overall area, the various zones and districts that all come together there, this lot has special conditions. And the second prong is there's no fair and substantial relationship. Why do we have this? We have this. The primary issue, in my opinion, is lot area per dwelling unit, to keep neighbors from being on top of each other, to keep air, light, stormwater treatment, etc. I personally think that the limitation not permitting a duplex or a triplex in this area, I think that's short-sighted, but you can't do anything about that. That's what the ordinance says. So we come to you for a relief valve to allow something that makes sense under all of the circumstances, and that's our position.
Thank you. Do you have the answer, Mr. Weinberg?
The light green area, including the building in parking, is about 25,000 square feet, which is about 40% of the lot.
Okay. So that really does reduce the lot area per dwelling unit to about 8,000 square feet.
Not at all, because the entire area is the lot. So it would be no different than having a 40-acre parcel and a single house on it, and the house is in the corner of the lot. It's still 40,000 acres or whatever to that one dwelling unit. It's still one lot, and what it would be preserved as open space.
I understand that, but my point is that the argument is that the size of the lot is allowing for 3 dwellings to go on it, and when actually it's only 25,000 square feet of the lot are being built upon.
So we could have come back with 3 or 1 giant building that spread across the entire lot, and we could have used up the entire forested area. So that's what we're trying to do, is preserve a lot of the open space. So we're trying to, make it a tighter development so that there's more open space, so that everyone can enjoy that open space and it's part of the lot.
Okay, thank you.
And I would just add to that respectfully, it's clearly lot area per dwelling unit. You can't. It is improper, in my opinion, to say, well, you're only building on part of it, so we only count that part of it. That's just not what the ordinance says. And Ms. Marginson, you had some questions about the floor plan and livable area. Do you still want to hear about that?
No, it was this question that I was
Okay.
had asked staff about. So, okay. Any more questions from the board?
Thank
Okay.
you.
All right, thank you. Now I'll invite speakers to come up. Those who want to speak to, for, and against. I will remind everyone that they have 5 minutes, and so those who want to speak for the project. To speak first, is it?
In favor.
In favor. Yes, those who would like to speak in favor of the project, please go first. And please identify your name and your address for the record.
Gerald Duffy, 428 Pleasant Street. So good evening, Madam Chair and members of the board. I'd like to say a few words in favor of this project, which in essence would result in creating 3 homes where one exists today. I'm not currently an abutter, but I did live for 2 years at number 594, which is just 2 lots away from south of this property. So I'm familiar with the neighborhood character and its traffic and everything about it. In granting or denying exceptions to our zoning regulations, there's no question that you all do difficult work. You have to apply the 5 statutory tests at each application, weigh evidence, and make decisions that at the same time do justice to both property owners and the community. Most citizens have little idea about the careful technical nature of your work and how much effort it takes, and I commend you for it. It's also understood that it's not the board's job to solve the housing crisis. However, I'd like to bring a kind of big picture perspective for you to consider. I've been participating in the 2024 Portsmouth Listens Housing Dialogue for the past 6 weeks. 12 different groups will report to the City Council in this chamber tomorrow night, and the city planning staff. And we can expect a steady drumbeat of 2 messages in particular from the many residents involved. One is that Portsmouth is experiencing a housing problem of crisis proportions. And 2, that it's time for urgent action. The group I was in concluded it's the city's role to enable the construction of housing for a wide variety of residents, from existing residents who simply want to stay in their homes to service workers who would be happy with a very small space close to their work. The recent housing market, the Portsmouth Housing Market Study, identified unmet demand for about 3,200 living units, including 2,700 rental units, the remainder single-family homes. So yes, we do need lots of workforce housing, but we also need more housing of the kind proposed here. To be clear, so it's understood that the land use boards cannot solve the city's housing crisis without enabling zoning regulations to do so. I think people recognize that it's a complex problem that will take a community-wide effort involving policy, zoning changes, public support, and the quasi-judicial boards all working together. If this project on Sagamore Ave produces a net increase of 2 homes in an eclectic neighborhood, that may seem like a drop in the bucket, but it would nevertheless be a plus for 2 families and for the community as a whole. Every new home, every new rental unit, and every new accessory dwelling unit makes a difference. So as you consider this application, I hope you can keep these factors in the back of your minds. Again, it's understood that it's not your job to solve the crisis. However, you do have some discretion, and it may be possible to take into account the urgent housing needs of our city. I hope you get a chance to watch the Portsmouth Listens presentations tomorrow evening, either in the council chamber here or via Zoom. And I hope our community sees our housing needs and solutions articulated in a soon-to-be revised master plan and zoning ordinances. So I appreciate your time very much and your attention. Thank you.
Thank you. Anyone would like to speak in favor of the application?
Good evening, Byron Matto, 17 Fields Road. I'm here in support of this project to allow 3 units to be constructed where a single-family house is today. This plan is not only aligned with the broader objectives of the city's housing policy, but also adheres to the criteria set forth by the zoning ordinance, ensuring that it contributes positively to the community we're addressing critical housing needs. The variance will not be contrary to the public interest. The transformation of a single-family home into a triplex directly addresses the ongoing housing crisis in our city, making it an initiative that serves the public interest. I should say that this point has just been deliberated by Mr. Rossi in the previous application this evening. This crisis, characterized by a lack of affordable and available housing, has been acknowledged by both the City Council and the Mayor as the city's top priority. Furthermore, there is a robust discussion led by Portsmouth Listens culminating this week that will enforce, again, the community's desire to allow for greater housing availability by a multitude of modalities, including this exact type of development. This property's unique location on a main city artery that could benefit from public transportation is the perfect example of the type of lot which should upzone. By increasing the housing stock in a manner that leverages existing infrastructure, this plan contributes to alleviating the housing shortage, thereby serving a critical public need. It aligns with the public interest by providing more housing options, enhancing diversity in housing choices, and facilitating access to affordable living spaces for more residents. The spirit of the ordinance will be observed. The spirit of the zoning ordinance, which aims to promote health, safety, and general welfare of the community, will be upheld through this proposal. By converting a single-family home to 3 units, the project contributes to a more efficient use of land, a principle embodied in zoning. It promotes a compact and efficient urban form, reducing the need for extensive infrastructure expansion and encouraging a more sustainable urban development plan. This approach to development is in harmony with the broader goals of the zoning ordinance, aiming to enhance the livability and sustainability of our community. Substantial justice will be done. Allowing for the conversion of the single-family home into a triplex ensures that substantial justice is done by balancing the rights of the individual property owner with the interests of the public. The proposal enables the property owner to make reasonable use of their property, which would otherwise be restricted by the literal enforcement of the zoning ordinance. At the same time, it addresses a critical public issue, the need for more housing, thus ensuring the interests of the wider community are also served. This balance between the individual rights of the public, individual rights and public benefits is at the heart of substantial justice. The values of surrounding properties will not be diminished. Do the people in this room who are so well versed in the housing landscape in the city of Portsmouth reasonably believe that allowing this raised ranch style home to be removed and this project be built as designed will diminish property values in the neighborhood and larger city? We would be so lucky as to curb just slightly the skyrocketing and discriminatory housing costs in the city. Not only will this will not diminish property values, but it will increase tax revenue for the city and allow for 3 families where there's currently only a solution for 1. Literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. The literal enforcement of the zoning ordinance, which restricts the property to a single-family use, would impose an unnecessary hardship on the property owner and the community at large. This restriction would limit the ability to respond adaptively to the changing housing needs of the city, exacerbating the housing crisis. This inability to adapt the changing housing needs is a systemic issue in the city and represents an exclusionary and discriminatory practice which is a fundamental hardship imposed on this community. The proposed conversion offers a practical solution that utilizes existing infrastructure to meet current demands, embodying the flexibility needed to address the unique challenges of our time. Granting a variance in this case allows for a reasonable use of the property that aligns with the city's broader housing objectives. And finally, I want to reference a state statute, RSA 674-59, which supports the notion that local zoning regulations should allow for flexibility and adaptation to meet the changing needs of the communities. This state legislation underlines the importance of local zoning authorities considering variances and adjustments that contribute positively to community development and address the critical issues such as housing shortages. The proposal to convert a single-family home in this case is a prime example of the kind of innovative and responsive planning that RSA 674-59 encourages, demonstrating a proactive approach to addressing the housing crisis. Thank you.
Thank you. Is there anyone else who would like to speak in favor of the application? Okay. Seeing no one rise, if we could have somebody's, is that the applicant himself? Well, seeing no one rise, I would invite those who are opposed to the application to please come up. Remember, you have 5 minutes, and please state your name and your address for the record.
Good evening, I'm Duncan McCallum. I live at 536 State Street. As you all know, I'm an attorney, but I'm not representing anybody tonight. I am speaking solely for myself. Now, the application which is before you tonight is quite similar to a great many variance applications that come before this board for disposition, because after you tear away all the fluff and pierce through all of the nonsense, the applicant's justification for seeking a variance goes something like this. I don't want to have to obey the zoning ordinance. I don't want to have to comply with the requirements of the zoning ordinance. I can't do what I want to do if I have to comply with the requirements of the zoning ordinance. Or, to cite a familiar variation of that theme, I can't make as much money as I would if I didn't have to comply with the requirements of the zoning ordinance. Well, if as an applicant that's all you have to offer, then there is no occasion for granting any variance, because that's what zoning is. You don't always get to do what you want to. You don't get to just do whatever you want to. Zoning is the reason why Walmart cannot erect a Walmart supercenter in the middle of a residential neighborhood. It is the reason why you can't open a strip club or an adult video store next to an elementary school or a middle school. It is the reason why you can't open a pig farm next to a row of waterfront restaurants. It is the reason why you can't erect a building that is too big on a parcel of land that's too small. But that's what zoning is. You don't just get to do whatever you want to. In order for a variance to issue, there has to have, under the terms of the statute, there have to be special conditions, which are sometimes known as the somewhat misleading term hardship. But as I'm sure you all know, the kind of hardship which justifies the granting of a variance is not the personal circumstances of the property owner. The hardship has to be a hardship in the land itself. There has to be something unique about the property and some disadvantage, such that it is unfair to require the property owner to have to follow the same rules that everybody else does. But just because you had a new baby and you need more room in your house, that is an example of the personal circumstances of the owner. It may be a personal hardship to you, but it is not the kind of hardship that justifies the granting of a variance. The fact that you entertain frequently and you want more room to entertain, that also does not justify the granting of a variance. It has to be a hardship in the land itself, which, as I say, is such that it makes it unfair to require the property owner to have to obey the same rules that everybody else does. Now, in this particular case, there is absolutely no hardship of any kind. There is nothing unique about this particular property which puts it at any disadvantage, and it doesn't give any reason for why this property shouldn't have to follow the same rules everybody else does. The property is perfectly typical of the other properties in the same district and the same properties in its surrounding. Basically, what this all boils down to is the issue here is very, very simple. The district is zoned for single-family residence, and there is no reason why the property owners cannot erect a single-family residence or let the single-family residence that's already there remain. There is no hardship of any kind on this property which would justify a variance. Now, it's okay, it's larger, my friend Mr. Phoenix pointed out that it is larger than some properties. Well, it's larger than many in that area, but it's smaller than some. And in any event, it would be inconsistent with the character of the rest of the zoning ordinance. Excuse me, I misspoke. Inconsistent with the character of that zoning district to allow the applicant's plan to go forward in this case. And as you know, under the Malachi Glen case, which Mr. Phoenix himself cites in his paperwork, you can't allow a variance if it's going to be inconsistent with the character of the neighborhood. The character or the neighborhood is single-family homes with deep lots, which have plenty of wooded area, presumably plenty of animals, plenty of interesting plant life, and gives the people in that zoning ordinance a sense of privacy, that they're free from overcrowding. And the
Attorney McCallum, your 5 minutes is up.
Okay, that's pretty much all I had to say anyway. Thank you.
Thank you. Is there anyone else who would like to speak in opposition to this application?
Hi, my name is Linda Brown. I live at 650 Sagamore Avenue, and I'm here again requesting the board adhere to the ordinance as written for a single dwelling property at the 550 Sagamore Avenue. We were last here on October 17th when a similar larger two-structure unit was being proposed. At that time, the board ruled that it would remain as originally zoned, single dwelling property, and the original structure would not be demolished. Kind of surprised that we're back here again today addressing this again. The only thing that's changed is the proposal was to decrease one structure which houses 3 condos instead of the 2 structures. The traffic is still a concern, which is very dangerous to the neighborhood. Cramming as many houses and using every inch of land to make more money is not a hardship. And threatening that if this is not approved, the house will be demolished anyway and 3 single units on a cul-de-sac will be erected feels very much like a bully on the playground to me. Again, I cannot help but think this is pure greed. Please adhere to the ordinance as written and keep this lot a single residence property. Thank you.
Thank you. Is there anyone else who would like to speak in opposition to this application?
Hi. Can you put the picture of what they're going to do on there?
Yes.
I'm Christina Willie McKnight. I live at 546 Sagamore, and when my house is on the right there, the bottom one.
Okay, if you could please stay near the microphone.
Sorry, my house is the bottom one there, on the map, the orange one. I am a sort of a newcomer to Portsmouth. We bought the house last December. I was here over Zoom for the last time this came up in October. And I'm really glad to be able to address you all in person because it's very important to me. When we bought the house, we lived in Massachusetts before, and so I wasn't familiar with New Hampshire. And I'm enough of a nerd that I've actually watched these hearings on Zoom previously while we were still in Massachusetts, because part of what is important to me is how the city makes decisions. This would obviously impact me and my family, my husband and my 2 children very directly. And I think that's important to note in terms of we were really glad to move to a place where across the street is mixed use. And we were really glad to move to a place where our side of the street is single zoning. It feels different. I walk our dog over in the apartments all the time, and I walk down our street all the time. It feels different. It feels different to how our house feels. I appreciate that the applicant said that this wouldn't feel different for anyone while coming down the street. It's going to feel different for my house. It's right there. It's going to be different than what I thought was sort of a covenant between the people who purchase and what the city is doing, because it matters what the zoning ordinances say. It's how we make decisions. I understand exceptions need to be made, and I think there's often really important reasons to make exceptions. This doesn't, to me, seem like one that, and I've thought about it a lot, is one that makes sense to me. And I understand I'm also it impacts me personally. So I'm thinking about it as much as I can personally and ethically, with as many windows as I can. I think the other important thing for me to say is that I don't think I would have bought my house if this was a 3-tenement condo. It's nothing against it. It's just not what we were trying to do for our kids and for our family. It feels different. And I understand there's like assessments as to how and why things will impact property value, But as a person who just spent the largest sum of money that I've ever spent in my life on a very specific place, that's not something I would have done if the zoning wasn't what it was. It matters. Thank you all for considering.
Thank you.
Thank you.
Is there anyone else who wants to speak in opposition to this application?
Paige Trace, 27 Hancock Street. I'm here with due respect to say there is no hardship this evening. In listening to the past speaker, I will say that the only hardship that I'm hearing is that somebody new to Portsmouth who made a tremendous investment and lives in, thanks to the miracles of Zillow, an 1,896 square foot house is going to have, if I heard you correctly, Chairman, there is 25,000 square feet of structure being built. Now, to put that all in perspective, most people may or may not know where I live. God knows I've said 27 Hancock Street long enough and many enough times. But our house is 38 feet by 45 feet. Now, it would take, if you counted all floors equally and didn't adhere to current practices, it's roughly, could be said, 5,000 square feet. So I would just say that you need to think of 5 27 Hancock Street houses, one after the other, after the other, after the other. And then you have the idea of what 25,000 square feet looks like for a residence. I don't think anyone would argue that we live in a fairly nice large house. But that is going to tell you what 3 families are going to share. As a condo, 3 condos, 3 houses, 3 condos larger than the square footage of our house. And I respectfully say, yes, we need housing in this town, but we need affordable housing for everyone. And that isn't the type of affordable housing that this city needs. So I respectfully say, with a structure that size, lump it any way you want to, but 25,000 square feet is mighty large next to 1,896 square feet. And I thank you for your time this evening. And with respect, I speak out against this project. Thank you.
Thank you. As we're calling up, if there's anybody else who wants to speak in opposition to this application, please do so. I do want to correct the record, though. The built-upon lot is 25,000 square feet. It is not the structure. So I apologize for confusing anyone.
Esther Kennedy, 41 Pickering Ave. I come before you because we have zoning laws that have been voted on, have been discussed, and have been put in place. I don't see a hardship here. I think that's really clear. So I ask you tonight to listen to the people that have spoke before me and after me that live in that area and support them, given the zoning laws we have today. If we need changes, then we should be looking at the zoning laws. But right now, you have what you have to work with. Thank you.
Thank you. Is there anyone else who wants to speak in opposition to this application?
Peter Hood at 280 South Street. I am not going to go into the housing crisis or anything like that. I'm going to focus on what you need to focus on. Basically, this is SRB single residence. That means 1 unit, not 3. This is not consistent with the neighborhood in the SRB district. The density is not consistent with the neighborhood in the SRB district. There is no hardship here. In the long discussion that their attorney put forward, I could not figure out at the end of it where the hardship was, and I don't think you could either. Please vote this down again. Thank you.
Thank you. Is there anyone else who wishes to speak in opposition to this application?
Good evening, Madam Chair, Board. Jim Lee, 520 Sagamore Avenue. We're a secondary abutter to this project. And having been a real estate broker for the past 43 years, I'm extremely aware of the housing shortage we have. I live with it every day. However, this is not the right place for this project. If you look at the zoning ordinance, section 10.440, it says in that district, in SRB district, you can't build 3 or 4 dwelling units on that lot. And you look at up above that at 1.30, you can't even build 2-family dwelling unit on. It's single family only, period. We go back to the reasons that you found to deny this application the last time. You said granting the variance would observe the spirit of the ordinance. The finding was no. The property is presently in conformity with the zoning ordinance, and granting the variance would make it more out of conformity. And the last one, literal enforcement of the provisions would result in an unnecessary hardship. The finding was no. The applicant's lot is bigger than some and smaller than some, but you found that the lot could be used in its present conformity, in conformance with the ordinance. So the explicit performance of the ordinance in the SRB zone is for single-family dwellings only. 3 or 4 dwelling units are expressly prohibited by section 10.440. So this application does not meet criteria 1 and is contrary to the public interest. The property is presently in conformity with the zoning ordinance, and granting the variance would make it out of conformity. Again, the lot is smaller than some and bigger than some. The lot can be reasonably used the way it is now, and there's a single-family home on it now. Granting this variance would not observe the spirit of the ordinance. And substantial justice would not be done because the benefit to the applicant is outweighed by harm to the general public, especially the 2 direct abutters. If this application is built as advertised, the McKnight family, who Christiana just spoke, will be looking at instead of a backyard, they'll be looking at a parking lot, an extended driveway for the 3 dwellings, not to mention 6 garage doors. On the south side, the neighbor Joan would be looking at a large blank wall along her property. I would submit as a real estate professional that could and likely would diminish the value of one or both of these properties. This application again fails the hardship test. There's no special conditions that distinguish this single-family residential lot from other properties in the area. This application is basically the same horse pulling a different buggy this time. This is the 3rd time this application has been before you, and I once again ask that you deny this application because it fails on all the required criteria. Thank you.
Thank you. Is there anyone else who would like to speak in opposition to this application?
Hi there, I'm Susan Harding. I live at 594 Sagamore. And again, am here to ask that you do not approve this. I want to support my neighbors and also feel that when I bought my house, I appreciated the land. So I appreciated the zoning, and I don't feel like you just have to devour every little piece of property to build something on it. I know there's a housing shortage, but again, I don't agree that this is the issue here. And I bought my house appreciating the peace and the quiet and the land and the trees behind it. Never, ever imagining that someone is just going to try to build all of this there. So I want to support my neighbors and ask that you do not approve this. Thank you.
Thank you.
Madam Chair, very quickly, what was the address?
594.
Thank you.
Is there anyone else who would like to speak in opposition to this application? Okay. Seeing no one rise, I would invite speakers to speak to, for, or against this application.
Thank you, Madam Chairman, members of the board. Tim Phoenix again. I'll be brief since I've already made my presentation. I just want to address a couple of things. One, the point was made by several people in opposition that this would take the property out of conformance. Well, that's what every variance does. It either takes it out of conformance or makes it more out of conformance than it already is. That's what this board is here for. There was mentioning about traffic on the road. We will have to go through planning board approval, which they may or may not require a traffic study. But one of the things that happens there today is it's one house, but you have to pretty much back out into Sagamore. That won't happen anymore because of the turnaround areas. The neighbors to the north and south, there will, as part of the planning board process, we will have fencing, we will have screening, which will help protect those people. Thank you, Madam Chair, for correcting the 25,000 square foot structure, which it's not. I had Eric determine the three buildings together cover about 5,650 square feet, or about 1,882 square feet per unit, including the garage. The fact that people don't like it, I understand, I get it, but I think you also have to consider the effect on this landowner, and to say this is greed is just unfair and unreasonable. They don't know the circumstances. On the one hand, people are saying personal circumstances don't matter, but then they come in and say you're just being greedy, which is a personal circumstance. I mentioned last time across the street the number of single-family units that were put up. Ms. Margison correctly noted that that was an improvement by residential use where there was a commercial use and a pretty rundown area. But the fact is, a hardship was seen there as a result of the situation, and this board granted variances to have the multiple units, which require variances for, I believe, density. We meet the density requirement of the ordinance. We just don't meet the three multiple dwelling units in one building. I understand the argument of what this zone says, but I don't think you can ignore the fact of the zones that are across the street and the intense uses of those places, those units. And if you go up and down the street, as I mentioned, a quarter of a mile, 0.2 of a mile, you have much greater density than we're proposing here. Thank you.
Thank you. Is there anyone else who would like to speak to, for, or against the application?
Good evening, Board. My name is Ted Alex. I live at 104 Lock Road in Rye, but grew up on Woodbury Ave in Portsmouth and also at Sagamore Ave. I'm the son of Francis Mafluzzi. I'm here tonight to talk about the request for the approval for 3 dwellings across that are located at 550 Sagamore Ave. I'm also here to set the record straight on the comments that were not true for those opposed to our application this evening and at our last meeting. My family hopes that you'll make the right decision this evening and approve the reduced submitted plan of 4 homes to 3 condos. To 3 homes. They are not condos. This plan still allows for over half the lot to be not developed and to stay in its natural state as originally proposed. We also redesigned the first home to face Sagamore Ave with the look of a single-family home, which was brought up at the last meeting, and some of those opposed had concerns about that. To set the record straight, our family are not developers. It's not about greed. This is all about keeping my mom, a longtime resident of Portsmouth, in assisted living, period. We hope the design of these 3 homes will give families an opportunity to live and enjoy Portsmouth as she has. My mom never thought of her neighborhood as a single-family neighborhood, which was brought up. Frances had friends on both sides of her home and across the street at Sagamore Apartments, which is 20 feet away. My sister lived at Sagamore to be closer to my mom. Never was the Sagamore neighborhood divided by Sagamore Street. It's a neighborhood. Or by a different zone area. It was all a neighborhood, not a single-family neighborhood, but a neighborhood that didn't discriminate from those who have and have not. The neighborhood with a triplex, which is 7 houses down from my mom's, and from hers on Sagamore, or an apartment building across the street with affordable rentals. They are all neighbors and residents of Portsmouth for the last 40 years, which she lived at the house. My mom grew up on Pleasant Street and is proud to be a puddle docker of the South End. My grandfather retired from the Navy Yard. My great-grandfather was a lifesaver stationed at Wallace Sands in the 1800s, and we're all descendants of Captain John Locke. My grandparents on my father's side immigrated to Portsmouth in 1923, owned Durgan Lane Dairy until the 50s when the government took the farm of 300 acres by eminent domain and built Pease Air Force Base, leaving my grandparents with 5 acres when my father returned from 4 years in the Air Force. My father passed away in 1973, leaving my mom with 4 young children. Not being able to afford the house and land, owing back taxes, she sold the house and bought 550 Sagamore Ave. I'm saying all this because we all have roots in Portsmouth. This is her legacy. My 91-year-old mom had planned on being here tonight to speak about her Sagamore neighborhood of 40 years, but my mom unfortunately passed away Monday after a fall in assisted living in Portsmouth. I hope tonight I was able to address her concerns about about the accusations of greed, assumptions that we are developers, in the discrimination against what a neighborhood should be as a longtime Portsmouth resident. My mom, though 91, was sharp and on top of all things Portsmouth. Our family truly thought she would outlive us all. But that wasn't the case with her dying Monday. My mother's major concerns were about families not given the same opportunity in Portsmouth she had in 1973, not being able to buy into the charm and qualities she had. Her mother, her great-grandmother, all enjoyed living in Portsmouth and calling it home. In closing, the message to you tonight was a message she thought about and relayed to us from the last meeting 30 days ago, which she watched on TV. She was upset and disappointed with the last decision. I've done my best to relay her thoughts to the board this evening. I hope you'll approve our request this evening. Thank you.
Thank you. Sorry for your loss. Is there anyone else who wishes to speak to, for, or against the application? Okay, seeing none, rise. I'm going to close.
We thought someone on Zoom.
Oh, that's right. I'm sorry. There's somebody on Zoom.
Hello?
Go ahead, Gary.
Yeah, this is Gary Cameron. I'm here with my wife, Patty, who is Francis's eldest daughter and Ted's sister. We live at 110 Fields Road, Portsmouth. First, I'm going to respond to the October ZBA meeting and the subsequent denial of 550 Sagamore. And as I just stated, in full disclosure, I'm related by marriage to the Mufluzzi family. I'll break this into sections. One, to address what I feel are the number of grossly inaccurate and inappropriate accusations, especially by former city council members and some community members that were levied at the property owner's intent. The second is to address why the ZBA should consider a hardship to the family, and then benefit to the public interest, which addresses the housing crisis in Portsmouth, in New Hampshire, and the nation. I'm going to, I had this section about what Ted Alex had posted in response to the October Seacoast Online Facebook post, but I think that he just covered what was needed to be said there. I will only reiterate that this was never about greed. It's just about allowing Frances to continue to self-finance her living with her few remaining years with some dignity and grace. She was moved there a year ago because she was having a hard time living alone and falling. We're concerned about her health. Frances Mufluzzi was born and raised in Portsmouth. She can trace her family back to Captain John Locke, as Ted just stated. Captain John Locke built the first meeting house in Portsmouth in 1645. Glad he didn't have to come before the meeting tonight. She spent her entire life working here, raising 4 children as a widowed mother, having to work 3 jobs, one of which was in the cafeteria at the New Franklin School, Now, that's old school Portsmouth. This is multi-generational Portsmouth working class family having to sell their home of 45 years to finance their mother's remaining years, which unfortunately has ended. Frances nor her family deserve to be libeled by former city council members or newcomers who can't respect the hard work of people who built this city. You have a right to your opinions, but not by disrespecting the real founders of the community. And I was especially upset at the former councilors coming out in October and what appeared to me to be a campaign stop against the lifelong Portsmouth resident and the multi-generational family. That didn't give me the impression of wanting to represent all the people of Portsmouth, but instead just a select group interested in fear-mongering. Then there are the abutters who just moved in the neighborhood a few months ago and want to close the door on our city of the open door. Or the abutter who portrays himself as an outstanding citizen while using my mother-in-law's property with a zip line illegally installed on the property. Next, in the ZBA findings of fact, the ZBA denied the proposal by stating that it failed to meet the spirit of hardship. Having to sell your home to self-finance remaining in assisted living to prevent falling does not qualify in the spirit of hardship. Can the ZBA consider that granting the variance is not contrary to public interest because it's a step towards relieving the housing crisis in Portsmouth, thus serving the public interest? ZBA also stated that the applicant's lot is a lot bigger than most and plenty of room for the applicant to put a 3-house subdivision there. Then it's certainly not a density issue. The initial application was presented in order to minimize an impact on the property abutters. I also take issue with certain board members stating that they won't vote to demo the existing home, which I don't believe is the purview of the ZBA. As already stated, the zoning in the surrounding area is mixed with apartment units across the street and an existing 3-family unit just up the street in the same zone. The zoning for this area states 1 to 3 units per acre. This property is 1.55 acres. Now, regarding the housing crisis, this city is growing,
Cameron?
and we need a fresh look.
Mr. Cameron, your 5
We need
minutes
it.
is almost up.
All right, thank you. I will close with that we need to do something in this city about zoning and housing crisis. Thank you so much.
Okay, thank you. Are there any other speakers on Zoom? Is there anyone else in the audience who would like to speak to, for, or against the application? Okay, now I can close the public hearing. And yes, I am going to call a 10-minute recess. We'll reconvene at 9:30. We'll deliberate, make a decision on this application, and then take up the other 2 applications. Thank you. Okay, the meeting is resuming. We're going to deliberate on the application for 550 Sagamore Avenue. So with the public hearing being closed, I would ask for motions, discussions, thoughts. Mr. Am?
Thank you, Madam Chair. So we've heard a lot of testimony this evening. Some of it, quite a bit of it, actually very emotional. My wife complains that I'm too unemotional and logical, so I'm probably the person to start this off and try and take us out of the emotional range and really look at this from how I see the board has to look at it, which is from a more logical standpoint. So, you know, this isn't about whose family has been in Portsmouth the longest. This isn't about who's the newest person to Portsmouth. This is not, in my mind, about a concept of greed. It's really about the fact that just like everyone, you know, for most of us, our property is one of our major assets. I know it's one of the largest assets that I have in my portfolio, and I think all of us want to try and maximize the value of that asset, both for ourselves or for heirs or whomever. You know, certainly we are affected by the passing of the owner, but at the same point in time, that is, again, not one of our considerations here tonight. We have heard that the ordinance is, you know, specifies this particular thing, and that is true. However, this board exists entirely to look at anything related to the ordinance. The entire ordinance is subject to being brought before this board and us looking through our criteria to decide if, in fact, the ordinance is being correctly applied to a piece of property or if it's being incorrectly applied. And that really goes back to the history of zoning. I mean, once upon a time, it was the wild, wild west. You could build whatever you want, do whatever you want with your property. It was all about property rights. Zoning is a method of all of us coming together and saying, well, we recognize that while I give up some of the rights to my property, you're giving up rights to your property, and in doing so, maybe we can live more harmoniously together and we're both benefiting something. And it has worked out very, very well. But that's not to say that there isn't a recognition that zoning is very cookie cutter. We've done a lot in this city more with things, with concepts like character-based zoning that kind of help to make that less so. But we recognize that when we apply this peanut butter spread of saying you're in this zone, that it may be entirely correct for your property, or there again may be special conditions. And as the applicant's attorney pointed out, the term hardship sometimes gives a connotation with that. But there are special conditions that says, you know what, when we applied zoning to that particular parcel, it did not necessarily make as much sense as it would for other parcels that are in that zone. You know, and especially in Portsmouth, the way it developed, I think we've discovered at this board that that is often very, very true. That we tried to do the best. The planning board and the city council tries to do their best to get zoning right, but it's very, very difficult to do with the variety of property sizes, considerations for each of them. So that really comes down again to our criteria that, again, logically and unemotionally we need to try and apply to every request. And first of all, I do appreciate what the applicant has tried to do in coming back before the board. I mean, I really do think I made some comments based off of my previous experience, and I do think that there have been some successes in Portsmouth with projects coming before us that were creative and used some innovative thinking to come up with something that, particularly from the characteristics of the neighborhood, resulted in something that started out as maybe not being within the characteristics of the neighborhood, but ending up being closer and more accepting, more accepted by the surrounding neighborhood, and passersby would not feel like, gosh, that's something incredibly unusual. And one other example, the applicant's representative talked about the previous case in Broad Street, which I was on the board for when we had that. Another example is on Union Street, where there was a large parcel that had what had been a factory on it called the Salad Factory, and that particular applicant came forward with a clever plan to, yes, have more units than what was typical in that neighborhood, but they made it look like it might have been, say, a former school building or something along those lines, and it really helped fit in. And, you know, if you walk by and look really carefully, you might say, oh yeah, that's really wasn't a school, but a casual passerby would say, oh, okay, that seems to fit with the neighborhood. So I think those kinds of creative solutions, and I appreciate the applicant making the extra effort to try and give us that creative solution, I think helped me with some of the criteria, but I still do think we have one fundamental concern that we have to get through. So kind of going back to our criteria, I think what the applicant did has helped me through the first two criteria, which is the spirit of the ordinance and the granting the variance would not be contrary to the public interest. So as talked about, that sort of goes back to the overall characteristics of the neighborhood. I think by trying to create this single-family look at the front and by putting the additional units to the rear kind of more hidden, but still looking like it could have been a building that had been there previously, I think helps with trying to meet that criteria. So I think that's a positive there. Going to our granting the variance would not be diminishing the value of surrounding properties. I think that also, it's a very wide open one to say that this added structure would somehow diminish property values, I think is a hard sell, so I think you're getting there. I think really where this application comes down to, in my mind, and for the rest of the board members to take a look at, is this idea of of the special conditions of the property. Is the fact that it is large enough that it could accommodate, in theory, accommodate 3 single-family homes on it. Sufficient reason to allow this variance to allow the one, and I understand that we're sort of smushing them all together, but the one structure being there. There's nothing to say, as the applicant has pointed out, that another person, there was nothing that in the previous decision by this board that said you could not demolish the existing home. That is not something that we say. That's nothing that our any particular ordinance in the city says. We do have a demolition committee for historic homes. Whether this would qualify under that or not would be a determination would need to be made. But it could still be demolished, and somebody could put a new structure on it of indeterminate size. The applicant's structure that they are proposing is within the total amount of square feet. In fact, it could be an even larger structure put on this parcel that would be in full conformance with the zoning ordinance. So to me, the key factor is hardship, special conditions. Does the size of the property allow us to go and make that final conclusion that this could be an acceptable use for the property, that the single-family zoning that was applied to it was not necessarily truly congruent with what this property is or could be. That's my initial thoughts.
Thank you, Mr. Rayom. Does anybody else have anything to add? Mr. Mattson?
Yeah, I think this project has a lot going for it. I'll touch a little bit on the first 4 criteria, even though I agree with David that the hardship criteria is the one probably most important. So I guess basically this single-family residence B zones, the parcels, the lot size only needs to be 15,000 square feet, and this is a 62,000 square foot lot. You could fit 4 single-family home lots on this size property, and that would be what the zoning ordinance considers to be a single-family residence area. And the way I would relate that to the hardship is, even though if you just look at the size of it, you could fit that many single-family homes. It's not only the size but also the shape of this property that affect it, because it affects how easily it could be subdivided, and our ordinance doesn't allow more than one freestanding dwelling on a property, which is partially why the previous project was denied. So if you end up here with this single structure, it's they're only asking for 1 variance, and this single structure results in 94% open space. So this is relating to the size of the property. It's a really big parcel. You have a lot of open space. There's definitely this effect of it looking like a single-family home from the street, which I think goes a lot in regards to the essential character. I think you could also apply, in addition to the size and shape of this parcel, its proximity to neighboring zones and what's on those in terms of the right across the street, the big apartments. That is part of the character of the neighborhood, and also that proximity can result in creating the combination of conditions results in something special for this property. So I think that can be, and then related to the hardship is this concept of it having the fair and substantial purpose of the ordinance. It's to preserve light, air, and privacy. And again, speaking to the 94% open space, and this single structure is entirely within the setbacks that are created and the density requirements that it meets. It handily meets the density requirements. It preserves the light, air, and privacy that would be expected. So for those reasons, I do think the hardship could probably be met, but I do think that's the hardest aspect of this project.
Anyone else wish to speak? Okay, well, since nobody else is going to speak, I'm going to say that I cannot support this application. I think that it does fail on hardship. You know, I think the argument is to maximize the use of the property for financial reasons. I completely understand that. However, there has been no demonstration to me by the applicant that this property cannot be used as a single-family residence. I think in terms of the character and of the neighborhood, I think the character of this neighborhood was very intentionally set out by the city. The Sagamore Court is garden apartments, mobile homes. Tide Watch is a planned unit development. And then you have across the street from there the single residence B zone. And I think probably a lot of that was because most of the lots are of a smaller size, and there are some that are equal to this size. But I think that the city was, I'm not always so sure about how zoning is done, but I think in this area, the city was very intentional with how they zoned this area. So I think there's a spirit and intent problem, but I think mostly it fails on hardship. I also think that, you know, for the abutter, you know, you buy into an area on the reliance of the zoning ordinance, and that the zoning will not change except for an exceptional circumstance. I don't think that this meets that exceptional circumstance. I don't think that this is a property for which a relief valve, which is what relief is mostly sought from this property for, it just does not meet that. So I wait a motion. I can make the motion. I wait a motion from a member of the board.
I'll make a motion to approve the variance as requested.
Is there a second?
I'll second that.
Okay, so speaking to the criteria, I'll take the first two together. The variance is not contrary to the public interest and the spirit of the ordinance is observed. The proposed use doesn't conflict with the explicit or implicit purpose of the ordinance. It's, again, the way the single-family residence B district is defined, it's at 1 to 3 dwellings per acre, and that's how you arrive at the 15,000 square feet per dwelling. And this is 20,000 square feet, or almost 21,000 square feet per dwelling. And it must not alter the essential character of the neighborhood, which again, that was actually my biggest issue with the previous application, is having the two duplexes and then fit back from the street frontage really created a different feel than with this project, you have from the street, it essentially looks like a big farmhouse with a barn attached, and there are other three-unit dwellings within proximity of this, or more, within proximity of this property. And it must not threaten public health, safety, or welfare, or otherwise injured public rights. And it was also pointed out that the current dwelling, to park and back out, you can't turn around on the parcel, so you have to back out into the right-of-way, whereas with this proposed design, you can drive forward when leaving the parcel, which I think would be, instead of threatening public health or safety, it would actually improve it. Substantial justice must be done. The benefit to the applicant should not be outweighed by harm to the general public or to other individuals. You know, I understand that this is a controversial project and so people might not like it, but if you actually look at any harm to the general public, I'm not seeing that outweighing the potential benefit of this applicant to make use of their property. And I think that this type of proposal is much better than a subdivision approach. The values of surrounding properties are not diminished. You know, it's always a topic of discussion, and we've heard from a professional appraiser for the applicants that the 4-unit project would not diminish the property values. So I think it's fair to say that a single building with 3 units in it would not. And for the hardship, literal enforcement of the ordinance would result in unnecessary hardship. Unnecessary hardship means because of the special conditions of the property that distinguish it from other properties in the area, there is no fair and substantial relationship between the general public purposes of the ordinance provision and the specific application of that provision to the property. And to address this, again, I think the general public purposes of the ordinance here is to preserve light, air, and privacy. And in this situation, that would be maintained because it's entirely within the setbacks and it meets the density. It's just that the special conditions with this lot that's more than 4 times the size of what's required in a single-family residence, and it's also relatively narrow and deep, and those factors combined with the fact that it's also in close proximity to other zones that allow greater density. That combination creates special conditions for this property. And the second part of the hardship is that the proposed use is a reasonable one. And this property, or this proposed building would not alter the essential character of the neighborhood and fit in with the residential purposes of the zoning.
Thank you. Anything from the second?
Yeah, thank you. I would actually like to put forward a stipulation to see if the maker of the motion would agree to it.
Yep.
So to address some of our discussion earlier, I would like to add a stipulation, if the maker of the motion is okay with it, that says that a building permit will not be issued until such time as the legal status of the board's action of October 17th, 2023 is resolved.
Yep, I accept that.
Okay. And I do think that could potentially address, the resolution could be that the applicant withdraws it or the court action is taken, but either way, if this motion passes, the applicant would be bound to make a decision on which way forward that they would want to go. So I do think Mr. Mattson did a good job. Just a couple additional considerations. Certainly with the barn structure to the rear, some of my question was the open space in the back versus trying to crowd that towards the front of the property, and in particular, concerns with the impact on it on the neighboring property at 576 Sagamore Avenue. I mean, that is the most affected from a light and air standpoint. At the same point in time, nothing that the applicant is proposing falls within the required setback for this zone. The SRB is particularly generous to the amount of buildable area. There's only a 10-foot setback on either side. SRA, which is across the street where we had approved the Luster King, requires bigger lots and is more restrictive on the setback. So, in that sense, I think the applicant is within their rights. I do think where it's placed is at least past the end of that current existing structure. So from a light and air standpoint, does sort of place that, probably the most imposing portion of the structure that the applicant is proposing building towards the back. And really, again, it comes down to this idea of the hardship. As was stated, again, this board's is not responsible to solve the housing crisis of the city, the state, or the nation. We are really, in my mind, looking at what this property has for characteristics. And I do agree with what's being said here is that the size and shape of this particular parcel has the ability that if it were subdivided, and I'm always cautious about doing the sort of the speculative thing, but at the same point in time, it is true that it is possible to subdivide it and continue to have the same number of homes that is what is being proposed here. I do think it more logically makes sense to create what is probably would be smaller units, more clustered together, which then again preserves sort of this open area to the back of the property that I think is of a general benefit to other property owners, especially those on the Walker Bungalow, and understand it is potentially slightly more impactful to those on the Sagamore end of the property, but I think overall as a holistic solution, it makes sense. And then we always do have this sort of question of the micro neighborhood versus the macro neighborhood. And this has come up many times in different applications that we've considered. Are we considering this against other properties that are immediately adjacent, or is it a bit broader to include a larger area around this property? And there's no distinct requirement that this board has to follow, and it is case by case, but I do think that there's a fair amount of variety in this overall neighborhood. And I do think that this property, with what is being proposed here, would not feel out of the characteristics of that larger neighborhood. And so in that more macro sense, I do think that it is meeting our criteria. So I do recommend approval.
Thank you. Any further discussion on the motion? Okay, I'll call the motion. So the motion on the table is to approve the application as presented and advertised, and I'll start.
With a stipulation.
With the stipulation that a building permit shall not issue until the resolution of the appeal with the Housing Appeals Board.
Yeah, basically the board's action of October 17th.
Okay. Mr. Masson?
Yes.
Mr. Ram?
Yes.
Mr. Mannel?
No.
Ms. Geffert?
Yes.
Ms. Record?
No.
And the chair votes no.
That motion failed.
That motion failed. So we will need, given that the motion failed, it's a tie, we will need another motion to deny, correct? All right.
It's proper.
All right. So, not that I'm fishing for motions, but I will see if anyone has a motion to deny. Can't look over there.
Yeah, I'm not going to.
Is there any motion to deny?
I made the last one.
I think.
There could be another motion to approve with different criteria too, just throwing that out there. I'm not saying that.
Just look
We're
at our-
just throwing out options.
I'm just gonna look at the board rules and regulations just to see.
Madam Chair, if necessary, I could act as the temporarily acting chair if the board agrees to it, to allow you to make a motion if you want.
That's the motion. Let me just do a quick review of our rules. So, if it results in a tie vote, the resulting decision is a denial unless a subsequent motion is made that results in at least 4 affirmative votes. If a subsequent motion fails to receive 4 votes, the chair will solicit comments for the record from these board members who voted against a motion to approve so as to document how the request failed to meet all of the criteria. So looking at that, it
Yep.
seems that we need to do another motion to approve. That's to see if we can get to 4 votes. Would that be consistent with?
That wouldn't be my interpretation. I just think it said that, the whole point, I think, of what we added in there was that right now, the applicant has no basis legally going forward to know why the board did not approve it. So what they're really looking for is from those who said no, what are the reasons for that denial so that they have a legal basis for doing that. That was our intent.
Reading this rules, I disagree. It seems that unless a subsequent motion that receives at least 4 affirmative votes, so it seems to me that there needs to be another motion.
But the subsequent
in the
motion would
affirmative.
be a denial, an affirmative of the denial.
No, an affirmative vote. I don't know if it's an affirmative vote to deny or affirmative vote to approve. Do you know, Steph?
You're past my understanding of what's going through your brain. Sorry.
So, and I think it's a tie vote, and a subsequent motion is made that receives at least 4 affirmative votes. If the subsequent motion fails to receive 4 votes, the chair will solicit comments for the record from those board members who voted against a motion to approve so as to document how the request failed to meet all of the criteria necessary to grant it. As I read that, it means that the subsequent motion needs to be another motion to approve. But
I was looking
For any motion.
I think it
Because
can
it
be a
just says
motion to
affirmative
approve
votes.
or a motion to deny, but
Deny.
you need to have a motion that passes.
Okay,
Right.
all right.
Right.
I will yield to the people who have more experience with tie votes than I do. So, again, I will ask for another motion to deny. And I would look towards the people who voted against it the last time. Just- Mr. Mantle, would you like to make a motion to deny?
Okay. I'll make the motion to deny.
We'll need a second, however.
Second.
I don't see the hardship. I appreciate everything the applicant has done to improve the project. And as much as I want to say yes, I'm bound by the rules. And the rules, I don't see the hardship in this property, that the special condition exists. Yes, it's a bigger lot. I wouldn't characterize it as narrow, considering it has 140 feet width. But I don't see the special conditions for the hardship.
Anything for the second, please, record?
I agree, I don't see what could be there influencing what they're proposing to be there. So maybe it could be a 4-house subdivision, but that's not what we're being asked about. And what we're being asked about, I don't see the hardship.
Okay, thank you. So I will call the vote again. The motion is to deny on the grounds of hardship, and I will start on this side this time. Ms. Record?
No.
Excuse me,
yes.
sorry, make this an affirmative motion.
Yeah.
Yes.
Yes.
A yes vote denies.
Yes.
Ms. Geffert?
No.
Mr. Mantle?
Yes.
Mr. Rayo?
No.
Mr. Mattson?
No.
And the chair votes yes.
Tied again.
So now we are tied again.
Right. And you have your comments for the record. I mean, I think you've solicited comments. I don't know if there's anything additional that any of the other members or
Great.
yourself want to make.
Can I make a comment?
Certainly.
So I guess I would say that, I don't know if I'm going to change any minds, but
Well, I just want to caution, the comment has to be on the motion. You have to
Yes.
solicit comments as to the motion.
Yes,
so.
Board Member Manels mentioned that the special conditions of the property not being, or addressing the narrowness of it. I think a way to consider that is the aspect ratio of it, and it's 434 feet deep, where a typical lot would only be 100 feet deep. So it's even if it's 140 feet wide, it's more than 4 times as deep. So if you consider a square versus a rectangle, it's an elongated, narrower shaped parcel. So
It's a rectangle,
yeah,
140 by 280.
it's.
Are you done? Mr.
Yep,
Smith?
I'm
I'm
done.
sorry. Mr. Ram?
I will just empathize with the makers of the motion. I agree that the criteria I struggled the most with was hardship as well. So I can certainly understand where the other board members are coming from and not being able to see what those of us who had made the affirmative motion saw as allowing us to grant it. So within that context, I would say that I think that makes sense.
Okay. So I think according to our rules, it's a denial of the variance application, and the applicant is free to take whatever comments, I guess, what if they choose to appeal this. So I declare the application has failed. So thank you very much. Sorry about that.
Twice.
Thank you, everyone. Okay, while everyone is shuffling out. Our next item of new business is item D. I will just ask people, if you're going to have conversations, please do it out in the lobby. We need to still conduct some business here for people who have been waiting a very long time. Mr. Rossi is resuming his voting seat. So the next item of new business is item D, the request of Cynthia J. Walker, owner, for property located at 46 Willow Lane, whereas relief is needed to demolish the existing shed, construct an addition to the primary structure, and construct a detached garage, which requires the following. 1, variance from section 10.521 to allow a 6.5-foot right yard where 10 feet is required. That is A. B of number 1 is a 2-foot front yard where 15 feet is required. And C, 28% building coverage where 25% is the maximum. Number 2, variance from section 10.571 to allow an accessory structure to be closer to the street than the primary structure. And lastly, 3, variance from section 10.321 to allow a non-conforming structure or building to be extended, reconstructed, or enlarged without conforming to the requirements of the ordinance. Said property is located on Assessor Map 133, Lot 18, and lies within the General Residence A District. Who is here to speak to this application?
Cindy Walker, 46 Willow Lane.
Michael Walker, 46 Willow.
Okay.
Okay, so our house at 46 Willow Lane is about 100 years old, and a very small house, just under 1,100 square feet, and it still has retained its original shape from, or more or less, from when it was built. We bought the house about 6 years ago with the intent on improving it, and given, you can see a little bit on that picture there, it has a pretty large side yard, and it really lends itself to improvement, especially because it is such a small house, and that many houses in the area have been improved upon that are that size. So because we've owned the house for a few years now, we've had a good opportunity to look at what is the best use of the space on the lot and the layout of the house. And so we are now ready to invest in this house and make it a much more livable house, maybe for the next 100 years. So we're asking for 2 items. First of all, well, 3, but 2 that I'm going to address. We're asking for setback relief in order to build a 1-car garage you can see where we have that placed there. The driveway will be extended to allow for 3 off-street parking spaces. Willow Spring Street, it's right on the corner there. And those 2 streets where they come together, they are just filled with pedestrians, dogs, and strollers, and people playing ball, but there are no sidewalks, so getting cars off the street really lends itself to the character of that area. And, of course, it will also be easier for the snowplows to get through. And as I said, the house has a large side yard, but it is located directly where Spring comes down to Willow. And so it's really a fishbowl offering no privacy as cars, drive towards the house. So because of this, we don't really use the yard very much, and so we don't really, use it, enjoy it. So placing the garage where we talked about here will accomplish the following things. As I said, lengthens the driveway so that we can put 3 cars, get 3 cars off the street. It creates a nice private backyard so that we can actually really use it and make the most of that nice lot. Also, by placing the garage, closer or away from the side of the house there, it will allow sunlight to come into the proposed addition. That will be the family room right there. And, so it won't block the sun. So make the proposed addition to the existing property much nicer. And then simply as Willow turns to Spring, placing a garage there will just create kind of a nice visual corner rather than a blank one that's there right now. So that's why we need the variance for the placement of the garage. And then the second thing we need is we're planning to extend the back of the house by 6 feet, so going that way. This is part of our addition plan. So the right side of the house is legally non-conforming already. So in order to complete the right rear of the house, right rear corner of the house when we put the addition on, we're just asking for relief to extend the legally non-conforming side by 6 feet. That will create a corner and not leave a little notch there, so the back of the house will be straight, it'll look right, and so that's just extending the already legal non-conforming side. Okay.
Questions?
Well, we have your submission, but if you could, thank you for describing the project. If you could briefly go through the variance criteria for the board.
All right, so this is our first time doing this, so just bear with it here.
It
So
might
the-
look like it's our first time.
What was that?
Nothing.
That's all right.
Join the club, please.
Thank you for doing this, by the way. This is not contrary to public interest, as far as I can tell. It doesn't seem to have any, the spirit of the ordinance will be observed because there's plenty of space between all the houses, so the setbacks would require a judgment from you. Substantial justice will be done. We will get a garage in the location that makes the most sense for the property. The values of the surrounding properties will not be diminished. Little enforcement would result in unnecessary hardship. I mean, this is always obviously the hardest one, you can tell from all the previous people, but it's, I guess, 1033.30. No fair and substantial relationship exists between the general purpose of the ordinance and the specific application of this thing. It's because it's kind of a unique lot, and there's lots of spaces between the houses on 2 sides. And B, our proposed usage is a reasonable one. So that's our hardship.
Are there any questions from the board?
Yes. Hello. Thank you for explaining the project and your support of the variance criteria. The only part of the project that still perplexes me a little bit is the placement of the garage. I agree with you that as things stand now, there's a lot of open space around that corner of your property.
Right.
I'm concerned, however, that in the future, pushing this garage up to within 2 feet of the front lot line it's kind of, it's almost like it's a, just because the owners of 50 Willow Lane have no plans on record right now of also expanding, the footprint of their structures, it's almost feels to me like there's a race to who gets there first, because clearly, if there's a 2-foot setback allowed for your garage, the light and space issue would be more difficult for someone at 50 Willow Lane if they were to want to build close to that lot line. And I'm not quite convinced that it's fair to just go on sort of a first-come, first-served basis that may eliminate options for other property owners that abut. And I agree with you that the property is unique. It's very interesting, let's just say the least, about the way it's positioned. But
Right.
what is your view of that? Why
So I
could,
talked to my neighbor about this
Yeah.
a lot, and he,
My mom was here, but
His
she
da-
left.
she was
That
here,
lives
but-
at 50 Willow, and she's supportive of the
she was
project.
going to speak on our behalf, but we decided a fence, we're going to put a fence along that line from there's an existing fence on the back. If you look at that, it's on the left-hand side. But it
Mhm.
goes all the way on the back, and I was going to continue it along 40 feet, which would come just beyond the front right-hand corner of the garage. So visually from his lot, you wouldn't see that, all you would see is the top of the garage.
but
above the fence.
could you run it by me again? Why would the garage not be moved back and attached to where you're building the addition? Because that would kind of eliminate the
So we'd have to move back
encroachment on the
15
front.
feet.
Well, I mean, you could go back a number of.
No, we could, no, so the original plan had it actually attached, just on one corner. Like where that bathroom is there, we sort of attached it, but we had to make, so you could make that turn into the garage. That's always been the problem, getting the car to come in there. Because if you go too close to that corner of the house, then you really can't get the car in there and out. It just makes it really hard to come in and out of there and park, and you can't turn around. The other option was to put it like further down, so you get more, but that even goes closer to the other house.
Further down, meaning to our left?
To
on this
the
line
left
there.
there, to the 10-foot setback over there.
Mhm.
I know, we put it all over, and that seemed to be the best place to put it.
And so this preserves like a private yard space, like I said, lets sun into the house, and
Right.
You were mentioning before that the space between, let me see, so the space between the house at 50 Willow, if they were to, they really can't add on to that space, just given the confines of the property.
Do you have a map, Joe, of that property looking down on it? Because his house is way in the back there.
You can see it
Mhm,
in the
yeah.
picture.
But I mean, the entire lot is,
So,
a
It
buildable
just seemed
lot.
to not make sense that anyone would ever want to put it. I can't speak for a future owner, obviously.
Right.
But they want to put the house closer because it's so nice back in there.
Mhm.
There's a big open space back in there, goes way back. And his current house is,
This one, right?
Yeah, I
is
drove
set
by
back
there
in
today.
So, no, I understand the whole idea if someone in the future
Yeah,
would be
but he's set back.
hurt by it.
So the garage would just kind of be tucked into that corner of the lot that, at this point, is not really used for anything. And there does not appear to be any objections from the owner of 50 Willow. In fact, we had discussions, he's in Florida, so he's not here. But we've had discussions and, he saw the kind of logic to why we placed the garage there. It's ease of use to get into the garage. It minimizes the really amount of like driveway, pavement, impervious soil, drainage, et cetera, that would need to be done. And it leaves as much open space and a private backyard as much as possible.
Thank you.
Any other questions from the board? Okay. I'm just going to ask a question, too. I had concerns about the garage, too, and I viewed the area on Monday. So the reason, I can understand the turning issue, but yet, if you tried to place the garage next to the house, that would not be a problem turning-wise. I mean, I understand you're trying to to
What do you mean
preserve
by
your open
turning
space.
wise? Turning to get into it, or?
Yeah, so if you put the garage more flush with the house, next to the family room addition, that might alleviate some of the concerns, but I just wanted to know why you chose not to do that. Was that for the preservation of the open space? Yard?
No, it was more like it just, we were gonna put a gate between the garage and the house too, so you can go behind the garage and there'd be a nice hardscape behind there. That was one of the other things. It would be a private little hardscape. When you come up the driveway, there'd be a 4-foot wide gate between the corner of the garage and the corner of the house. So that would be, that'd just look nicer, and it seemed like a good thing to do. If we pushed it back, like you were saying, so you have to push it all the way back to be able to drive, turn and go into the garage, and the door would face to the left. That's the only way to do it. And then we'd have to make the garage wider and the wider door. Because in order to make a turn in like that, a sharp turn, you'd have to have a, because we were gonna do like a 9-foot wide garage, so we'd have to probably do more like a 16-footer just to get in. And then we'd have to turn around to get out. So that's why we didn't do that. We looked at every possibility
Yeah.
that we could come up with, so this seemed to be the only one. And I wasn't gonna do it if my neighbor had a problem with it. I told him, if you have a problem with it, we're not gonna do it. But he thought it was fine. And we just talked about a fence, that's all, so.
Okay, thank you. Any other questions? Okay. So is there anyone here who would like to speak in favor of this application?
Not anymore.
Speak against this application? Or speak to, for, or against? And no one's on Zoom? I don't want to miss. Okay, so seeing no one rise, I'll close the public hearing, and I'll ask for the board's thoughts, motions, deliberations. You've been kind of quiet over there tonight,
I know.
so this was side.
David's got his hand raised.
Mr. Ryu?
Deliberation. So for this project, the only thing I have some potential heartburn with as well is the garage. When I was looking at it, 2-foot setback where 15 feet is required is a pretty significant ask. In general, try not to get that close. Through some of this discussion and thinking about it, I am okay with it, and here's my reasons why. So I think kind of what you were talking about, or any proposal to turn the garage 90 degrees and either put it up against the house or somewhere close to the house. I mean, I have a friend who has a situation like that with a garage that he went and built, and it is almost impossible to get a car in and out of a garage into that tight turning radius. You're either backing it in like a really awkward way, or you're backing it back out in a really awkward way. It's kind of a nightmare. Could they have gone and put it, further back and then up into the yard a little bit? That would have, given us some relief. In my mind, that's possible, but then you're adding, as noted, impervious surface, more pavement, and more importantly, I just don't think you're going to get that much more light and air relative to the neighboring property. Now, I understand that the current owner of the neighboring property is good with it. Again, we need to be cautious about that. This is in perpetuity. Owners change. We really need to look out for the concerns of owners going forward. But, and they, as they have pointed out, the current advantage that they have in that, for some odd reason, that little structure that's on that property, which at some point in time, I'm guessing it's going to get changed because that's just the nature of the way things are going in Portsmouth now, it is all the way tucked over to the far corner, probably would get changed at some point in time. But again, I do think that kind of with unique circumstances here, and the fact that this is a very modest request for a garage, it's not very tall. If it was much taller or bigger, more imposing, I probably would have heartburn with it, with what is being proposed, although I'm normally not very receptive to such a small setback. I think I could live with it.
Okay, so I wonder if I sense the beginning of a motion there. I will say that if no one else is going to speak. I had concerns, the same exact current concerns, the 2 feet off the property line, the front yard. Also, that the garage being closer to the street than the primary structure. It's been kind of a sticking point with me. However, I do think because this is a corner property, that's probably less of a concern here. So I would await a motion, perhaps, from somebody.
Yeah, Madam Chair, if you want, I'll follow that up as a motion to approve the variances as requested and advertised.
And is there a
Second.
second? Okay. Mr. Ram, your motion?
Thank you. So I had discussion on this. Granting the variance would not be contrary to the public interest, and granting the variance would observe the spirit of the ordinance. So one thing is that we are looking at is the 6.5 feet off of the property line. That is to the back of the property. It is really just sort of an extension of an existing line for the existing home. Therefore, there's really no public interest there. Or change of the characteristics of the neighborhood that would be observed. The single-car garage, I mean, in terms of the overall characteristics of the neighborhood, single-car garages are pretty common overall in this neighborhood, although I would have to say in this specific little pocket, doesn't seem like there's as many of them as there are in some of the Lincoln Ave area and whatnot. And in many cases, you do see those garages kind of pressed up against the property line, usually because they're sort of long, narrow lots, and that was kind of like the only place to go and put it. So I think in that term, in that sense as well, what's being asked for here is somewhat congruent with the bigger overall neighborhood where you see that you have these garages sort of tucked into locations that are probably closer than what we would normally have for setbacks in other neighborhoods. Granting the variance to do substantial justice. So I think overall, especially with sort of this being this sort of odd configuration for this lot, I just don't see anything in the public purposes that says that the arrangement that the applicant is asking for, being slightly over the total amount of lot coverage is really not going to be perceived. The single-car garage and its placement, again, with sort of the unique characteristics of the interlocking properties that we have here, there's really nothing that the public would have for a negative impact that we would be concerned about. Granting the variance would not diminish the values of surrounding properties. Again, what's being asked for here for relief is a small extension off the back of the property, an overall coverage that is just slightly greater than what is asked for. And again, the potential biggest sticking point would be this single-car garage, but again, it's a very modest garage request. Its impact on the neighboring property, although very close, is probably not excessive, and therefore impact to the property values would not be there. And then hardship, what is unique about this property? Again, the corner lot location, the existing home, admittedly the plans to go and expand upon it are not insubstantial, but are sort of the logical direction that the applicant would need to go to expand the home. And then sort of the current distance of the current home and where the expansion kind of needs to be, as sort of discussed, is really no great way to just sort of add the garage on as an extension to that proposed expansion to the property. It really kind of needs to be in the orientation that it is, and putting it anywhere else on the property really adds only minimal benefit in terms of its setback to the neighboring property, with a lot of additional impervious surface, loss of open air for the other portions of the property, spreading the structures out. So really, I think it is a reasonable use, fully residential, reasonable request within those constraints of the sort of the unique nature of the property that's here. So with that, I recommend approval.
Does the second have anything to
I
add?
agree with everything Mr. Riom said. When I drove by the property, I immediately recognized the problem, and I have no problem with the garage being there. If your existing house is where your addition is, that's where the garage would be, because it's a straight shot from the street. Yeah, I mean, I will support the motion.
Thank you. Then I'll call the vote. The motion is to approve the variance request, and I'll start with Ms. Rickard.
Yes.
Ms. Gifford?
Yes.
Mr. Mannel?
Yes.
Mr. William?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes. It's a unanimous. You have.
Thank you.
Thanks. Thank you very much. Thank you for your patience. And the final item of the night, although adjourning will be the final item of the night.
We
The
hope.
final item of the night, under new business, application E, is the request of Joel and Jessica Harris, owners, for property located at 2 Monroe Street, whereas relief is needed to construct an enclosed breezeway, landing and staircase, which requires the following. 1, A variance from section 10.521 to allow 27% building coverage where 25% is the maximum allowed. And 2, variance from section 10.516.10 to allow a 10-foot front yard where 12 feet is required by the front yard exception for existing alignments. Said property is located on Assessor Map 152, Lot 8, and lies within the General Residence A District. And who is here to speak to this application?
Good evening. My name is Joel Harris. I'm the property owner.
Okay, thank you.
I will make this as brief as possible. Thank you all for your consideration and time. I would like to note that this is an after-the-fact variance. We came here about 2 years ago and got a variance to construct a breezeway. During that construction process, we decided that it would be nicer to have that breezeway enclosed with a front door. We asked our contractor if this would be an issue. He assured us it would not. Constructed the breezeway as approved, and then enclosed it. By enclosing it, he had to add a 3-foot landing for the door, which wasn't previously there, which pushed us that 2 feet closer to the property line than is allowed. This same landing is also why we're going from the approved 26.5% lot coverage to 27% lot coverage, because it's adding an additional 17 square feet. So, not to throw my contractor under the bus, but we asked him if it would be okay, and he said it wouldn't be an issue. So, I have since taken over the application from him, and I'm coming before you with this new application. As far as the variance requirements, the variance will not be contrary to public interest. There's no existing public sidewalk in front of the property that would be impacted by this. There's actually a substantial bump out in front of our property that is city-owned, which is kind of the issue. So it is green space with a tree, so it's not impacting any closer to the road or to a sidewalk, because there's no sidewalk. The spirit of the ordinance will be observed. With our existing conditions, there's limited design options. The existing condition, our stairway before this construction was not compliant. And if we were to do a stairway that was compliant, it would affect parking spots that already exist. So it would be difficult there. Substantial justice will be done. Like I said, the existing condition was not to code. There was no landing at our previous front door, which required us to stand 2 to 3 stairs below the door and then open it out. So it was a very awkward entrance. Value surrounding properties will not be diminished. We're a corner lot. Really, the only comparable property is next to us at 18 Monroe Street, and they have a stairway that extends all the way to the street. I don't know if you want to show that picture there.
Which picture?
Go down.
Yeah, that one there.
Yeah.
So our house is on the left. The only comparable really house is on the right, and they have a non-conforming stairway that comes all the way out to the road. So ours is going to be significantly less than theirs. And then the hardship. Again, if we were to construct a stairway that met code, we would have to do 2 landings. They would wrap around and go into the existing parking area. Also, being on a hill, we have to have a certain grade of our stairs to get down to street level. So that kind of takes care of that one there. So, questions?
Actually, that's for me to ask.
Oh, sorry. I was trying to rip through it.
Mr. Rossi.
Could you state the name of your contractor, please?
Should I?
That's my question.
Okay, yeah, that's Daryl Cook from Trio Construction. I guess that's dissolved now, and I don't know what the name of his new company is.
Thank you.
Mr. Ram?
Yeah, so the one part of your story that you haven't said is how did this come to the attention of the planning department that brought you here tonight, that this was in nonconformance? Because it looks like it's been this way for a little while, right?
It has been. We got a stop work order, which we've adhered to. There was some discussion with the planning department on what needed to be done, and then when I took over the application, I solicited my brother-in-law's help to do this, and then with the holiday, I missed the last meeting, so it's been a little while.
So was the stop work order generated from like a building inspection?
Yeah, I think he had a building inspection.
Okay.
I
The building
think-
inspector maybe just identified there might be a discrepancy with what was originally expected when they came to.
Yes, because the original approval was for a breezeway that wasn't enclosed.
Okay.
Which, that's not the issue that's being enclosed. The issue was that by enclosing it, we had to put a landing in front of the door, which pushed everything out 3 feet.
Yeah, I mean, I think enclosing it is a little bit of the issue, but yeah, okay, understood. All right, thank you.
Any other questions? Okay. Is there anyone here to speak to, for, or against the application? There is not. There's nobody on Zoom, staff? Okay. I will close the public hearing and await the board's thoughts, deliberations, motions.
I just have to say that I was expecting the partner of the owner to stand up and say that the hardship without the stairs resulted, but the stairs are already there, as we know. The other owner, for the record, has a broken foot.
I know that's not funny, but it is funny in that context. So I think that had this been part of the plan originally, it would not have affected our decision about whether or not to approve the original variance. The change in lot coverage is really de minimis and should present no problem at all. It's clear to me that it was not the intention of the homeowner or the property owner to work outside of the approved variance and outside of the zoning ordinance. So I'm fine with it.
Is that the beginning of a motion, Mr. Rossi?
Sure.
Just
Wait
a
a
ray of
second.
buttering.
I did most of the motions, except for the hard ones. I would make a motion to approve, is this called a retro act?
Retroactively as presented,
Yeah.
I guess.
I make a motion to approve of the variance as submitted and advertised.
Is there a second?
Second.
Mr. Mennel? Mr. Rossi, your motion, please.
Okay, I've got to get out my little cheat sheet.
Need that.
Yeah, with regard to the first two criteria, taking them together and thinking about the project and the impact that this particular aspect of the variance would have on fitting in with general characteristics of the neighborhood, really makes no change in the characteristics of the house, and it does still fit within the overall characteristics of the neighborhood. So I believe those criteria are satisfied. The substantial justice would be done, particularly since this is a retroactive variance that we're granting. There would be a pretty significant inconvenience to the property owner if we were to deny this variance, and therefore there would have to be a commensurately significant benefit to the public in doing that, and I don't see that as being a possibility here, so that criterion is also met. Granting the variance would not diminish the values of the surrounding properties. Again, it fits in perfectly with what's going on in the surrounding properties and really doesn't alter the characteristics of the overall construction project, so I can't see it having an impact on property values one way or the other. And literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. In hardship, we're always looking for special conditions of the property that affect the variance that is being applied for. And in this case, the special condition is that the construction has already been completed, and it's kind of a fait accompli with no good reason to change it. So I would say that the hardship criterion is met.
Anything from the second?
I would agree. If all of this was brought up in the original application, I have no doubt it would have been approved in the first place. By the way, you did a great job with the house. I've seen this house for 30 years in town. It was waiting for somebody to take care of it. I support the motion.
Okay, so I will say that I will support the motion. I do have a problem with after the fact variance request. However, I'll, of course, we'll take you on your word that it really was the contractor's problem. I do agree with Mr. Rossi that had this been part of the original application, it probably would have passed muster with this board. The variance request is really pretty minimal. It's 2 feet on the front yard and 2% more on the building coverage. And my guess is that this this experience has been painful enough that it'll act as a deterrent for any future after the fact variance request. So with that, I will support the motion and I'll call the vote.
I just have one comment, if I may.
Sure.
Actually, I believe it's only 0.5 of 1% is the increase, and just goes back to what the planning staff currently does, which I, argued for a long time of, don't put in 0.5% for building coverage, put it as, go to the nearest whole number, and, part of our issue would have been solved with that, so.
Okay. So I'll call the vote.
Wait.
Oh, I'm sorry, Emma.
I'm so sorry. May I say something?
Yes, of course.
Thanks. I totally agree that there's an unnecessary hardship here, but just for precedent purposes, I don't want the hardship to be somebody bungled a construction and created a hardship. So I would just say that here, if I may, if the motion maker will just, and the board will consider, may I make a further statement about the hardship?
Certainly, you're not the second, but if the second and the first would accept the
Fine by me.
Yeah, and it's just because I don't want a precedent, because I'm about to go
Understand.
create a deck on my house and then come, I'm just kidding. So if it's okay with the motion maker and the second, that there are special conditions on this property that weren't created because there was construction. It actually is a property that sits, there's no sidewalk, there's no street. It's an unusual lot in that way. And so I think that's the special condition. And then once you acknowledge that, getting closer to the front of the yard is kind of an irrelevancy for this particular property because of its special characteristics. So there's no fair or substantial relationship between the public purpose of the ordinance, which is a real setback from the public space, and this particular property because of the odd frontage that it has. So that's why I think there's a hardship.
I would amend my motion to include Ms. Geffert's comments.
Thank you. Point well taken. So the motion is to approve the variance. Does anybody else have any comments before I call the vote? And where was I starting again? I think
The only other comment I have is that I think we are seeing too many retroactive, or whatever they're called, after the fact variances for my comfort. We've seen them a couple of times over the last few months, and I don't know what's going on with the contractors in Portsmouth, but I hope they understand that this is public information, and while it's not our purpose to, keel haul anybody for making a mistake, I think it is important for Portsmouth property owners to understand which contractors are able to comply with the zoning ordinances and which ones are unable because of lack of knowledge or whatever the case may be. And that is why I asked to have the name of the contractor stated for the record.
Is there any further comments?
Just toward that end too, I mean, this also may be reflective of, our building inspectors, understanding and being more sensitive perhaps to some of the requirements of the planning department as well. So could be a combination of both things. We're just getting better at identifying the issue as well.
Yeah, absolutely. I don't mean to imply bad intent on anyone's part. It's not within my capabilities to discern anyone's motives for anything. So certainly could just be complexity, but some contractors seem to be better at it than others.
Okay, thank you. Is everybody done? Okay, let's call the vote. Mr. Mattson?
Yes.
Mr. Rossi?
Yes.
Mr. Rayo?
Yes.
Mr. Madl?
Yes.
Ms. Gefford?
Yes.
Ms. Record?
Yes.
And the chair votes yes. Your application is approved.
Thank you very much.
We await a motion to adjourn.
Motion to adjourn.
Second. Second.
All in favor?
Aye.
Aye.
Aye. We're adjourned.